Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul, and along with my trusty sidekick, Ellie, we will guide you on a 3-hour journey through Courtlandia, starting with Judge Anzalone. But before we go there, Barbara already gifting 5 memberships. Thank you so much, Barbara.
53DM, Kristen Smith versus Brandon Smith. Kristen Smith is appearing via Zoom. Brandon Smith is present in person. So this is a date and time set for a show cause. Looks like we were here on August, well, let's see. It says here you're ordered to pay child support in the amount of $1,011 a month. Your arrearage as of today is $12,179.88. You've been making payments since March, but all except 1 month were significantly lower than the charged amount. And we have no income withholding. So, sir, first, do you understand once it reaches 10,000, you can be charged with a felony by the state of Michigan?
I was not aware.
Okay, so the Attorney General reviews these files, and if they determine that this should be charged, they, not us, not our local prosecutor, they can charge you with a 4-year felony. And what happens then is you're incarcerated until you can pay 20% down, which is difficult for a lot of people. So it is a crime to fail to pay child support. Do you understand that?
I do not.
All right. And let's see, we don't have an income withholding, and your child support is set at $1,011. Are you currently employed?
I am not.
Why not?
Because I'm self-employed. My significant other and I have started a business, and we're trying to get our feet off the ground.
So do you understand that's irrelevant? Do you understand that you have to pay your child support?
Yes, sir.
And if your new business doesn't allow you to pay your child support, then you get a job.
Yes, ma'am.
And then you work on your business until your business is successful. That's how you do it. Do you understand that?
Yes,
where were you working when you were being charged $1,011?
It was TNR Total Lawn Care in Morenci, Michigan.
Okay. Well, I will tell you, lawn cares usually take anybody back. So, sir, you don't get to not pay it. Right. And, you know, and I tell people that want to go back to school or do things like that, that's fine, but you still got to pay your child support. So figure that out.
I do plan on going downstairs after this, and I have $2,100 to put towards it.
So why don't you go down and do that and bring me your receipt back up? Okay, go ahead.
Thank you.
Thank you. All right. Now,
Barbara, thank you for $10 now. Let's make it a great week. Second session starts today. Yes, it does. Our brand new show, an afternoon show, 2:30 p.m. Eastern, 11:30 a.m. Pacific, right here on this channel.
all right. Come stand right there, sir. This is in the matter of file number 2007-31974 DP in the matter of Ashley Wetzel versus Nicholas Moore. Miss Wetzel is not present. Mr. Moore is present. This is a date and time set for a show cause in this matter. This is arrearages only. So, sir, you have a balance of $837.49. You did pay $287.28 back in May. Are you able to pay something today?
Yes.
What are you able to pay today?
So at least 3. Not
So you have to speak up. You got to speak up for me, and I know it's hard. I understand that.
I'm just trying to. I just had surgery.
So here's the deal. You have it's arrearages only. Right. And you don't have any other cases charging, right? Say it.
There's one in Washington, my youngest daughter. I've been working with them.
How about, would you be able to pay $100 a month on this? Okay, so what I want you today is pay $200. And then going forward, I want you to pay $100 first week of the month. Okay, so if you pay 200 a day, it'll take it down to 637, and if you keep paying $100 a month, it'll be done within the next 5 months, okay? All right, so I'm going to adjourn this out to a date. Miss Adams, when would be the next date, please?
Next Monday.
No, like, yeah, on a Monday about, it's August already. How about like November, first one of November?
Okay. November 2nd at 8:15.
Okay, we're gonna adjourn this to November 2nd at 8:15 in the morning. So I want to see 200 paid today, then $100 in September and $100 in October, and then either bring the $100 with you on the 2nd or pay it otherwise that week, okay? All right, you'll get a notice in the mail, all right?
And if this is paid in full beforehand.
Then you are done with me. And you just got to deal with Washington. Okay? All right, thank you.
Thank you very much. Did you want me to come back up with?
Nope. You're good. Thank you. All right, gentleman in the green shirt, do you have a friend of the court case?
Yes, Charles Senior.
Come on up.
I didn't see no judgment.
Yeah, what's your name?
Charles Senior. I seen it downstairs.
What's your last name?
Senior, SENIR.
Are you sure you don't have a friend of the court referee hearing or something?
I might, I don't know if it's, they told me come here.
Okay, who's your, who is Jeff or Mr. Anderson or Mr. Vasquez?
Your Honor, he
Anybody
should be
know?
in Judge Allsaver's court.
Oh, go next door.
Right next door.
Yep. Okay. All right, and last but not least, gentleman in the back, why don't you come up to the podium? Mr. Ladd?
Yeah.
Okay, so this is file number 2010-34945DM in the matter of Janet Ladd versus Mark Ladd. This is the date and time set for a continued adjournment. All right, so your arrearage right now is $10,700.55. You did turn in a letter from the Social Security Administration saying that we have found that you meet the medical requirements for disability benefits. So where are we at now?
I've got my monthly. I'm on my second month now.
Okay, so.
As far as paying FOC, that's the feds, not me. I bought that paperwork to you.
No, hold on. So, this is arrearage only. So the children don't get a stipend. Right, Mr. Anderson and Mr. Bach? My understanding is if they were minors, are these children minors? Oh, they are. Okay, so they would get a monthly check if he qualifies for disability. Mr. Anderson?
Yeah, I don't have that information in front of me, but yeah, that's typically correct.
So, Mr. Anderson, how do we move forward on that?
If he can show us proof, we can have a review done and then have it adjusted.
Okay, and have you received any documentation on what the kids are getting? No?
Yes or no, sir?
Uh-huh.
Yes or no?
You got to answer, that's all.
They, the money for the 10,000 you're talking about, the back payment for 6 months, that goes to that. That pays FOC. I don't see that. I'm not getting that.
So you didn't get the back pay. So
Okay.
is there, Mr. Anderson, is there an intercept on that?
That's
Yeah, there should be. I don't have any record of that right now, but that's something that we can definitely look into. I didn't know that that was sent out.
Okay, so Mr. Ladd, here's what I'm going to do. I'm going to dismiss this. They found out you met the requirements, and Mr. Anderson will follow up on that. And if we need to bring you back in to talk to you about it, we will. But I'm just going to dismiss it at this point. All right.
I can't tell you who it is, but it's the feds that give me my check are the ones that are paying now. It's got nothing to do with it.
So, yeah, because you didn't get a lump sum. It went to us, so we'll get it at some point.
So
All right.
unfortunately, when you're waiting on the government.
Well, we know that.
Yeah.
So, all right, Mr. Lag, good luck. Thank you. All right. Finance. Mr. Anderson and Mr. Vasquez, I don't know who has Mathis, but I don't have paperwork.
Right, that should have been adjourned to September 14th, and I believe we also need an updated phone number.
All right, Miss Mathis, I'm gonna call it.
Yes,
This
ma'am.
is file number, hold on, 2021-48285 DM in the matter of Charice Mathis versus Carl Mathis. So Miss Mathis, this is being adjourned to September 14. Our friend of the court enforcement officers try to call everybody when there's an adjournment, and evidently they had some difficulty calling you on Friday. So I'm gonna put you in a breakout room with Mr. Anderson so he can verify your phone number, okay?
Okay.
All right, so, and then once you're done talking to him, you are all set.
Thank you.
And we'll be back September 14 if we need to. All right,
Thank you.
hold on. Yeah. All right, so Mr. Anderson and Miss Mathis, go ahead and join that breakout room. Okay, Momir. All right, Eric Momir, you could start your audio and video, please. This is file number 2011-36946DP in the matter of Takoya Jarrell versus Eric Momir. This is a date and time set for an adjourned show cause. We were originally here on January 12 of 2026. At that time, the arrearage was $1,671. As of today's date, it is now $2,362. This is at least our third show cause. We did receive a payment of $69.64 on July 29 of 26. A friend of the court states that you are only making partial payments. We do have other cases and we're not sure what your employment status is. Miss Underwood, is this one of yours?
I don't believe so, Your Honor.
Okay. So Mr. Momir, are you currently employed?
Yes, Your Honor. I am I'm about 4 months into a new job. I was unemployed for about 4 or 5 months, and that's kind of why I got, so far behind.
Where are you working?
Yeah, it's called Carver Nonwoven. I'm a second shift supervisor there. It's in Fremont, Indiana.
Okay, can you give me the name again?
Yeah, it's Carver, CARVER, Nonwoven. So I think the last 2 or 3 checks it's started.
Hold on.
Yeah,
you said Carver, you're kind of a little bit muffled. Carver what's that last part of it? Spell it.
Yep, Nonwoven. So NON-WOVEN.
That's what I thought it was, in Fremont, Indiana.
Yes, ma'am.
Okay, Mr. Anderson, this is yours. So this is Eric Momir. He has obtained employment, Carver NON-woven, WOVEN, in Fremont, Indiana.
Okay.
All right, so here's what I'm gonna do. I'm gonna adjourn this out to November 2nd to monitor payments. Understand that you're required to pay $310 a month. Even if they don't take that amount out of your check, you still have to pay it. Got it?
Yes, yes, Your Honor.
Do you get paid weekly or bi-weekly?
Yeah, I get paid weekly, and they just started taking money out, so I haven't really figured out exactly what the math is with what they're taking out, where it's going, and all that.
You have an arrearage, you need to pay that down.
Yes, ma'am.
You know, if they're not taking it out, it needs to be $80 per paycheck.
Okay.
All right?
Yep, that helps.
So
Thank you.
we'll see you back on November 2nd, and hopefully those have kicked in. Make sure you keep your phone number updated with front of the court, because if they adjourn it, they will call and let you know. All right?
Yes, Your Honor.
All right. Thank you, Mr. Momier.
Thank you.
All right, Miss Underwood, let's see here. Miss Underwood, you were appointed on Mr. Ladd, were you not? Okay. In the matter of file number.
What was the name?
Hold on, Rhonda. In the matter of file number 2005-29090 DP, Georgia Tyndall versus Jamal Davis. I do not have any paperwork on him.
That I do see on my schedule.
Yeah. Mr. Vasquez or Mr. Anderson?
Your Honor, I'm showing Mr. Bowe adjourned Mr. Davis to October 26th.
All right, thank you. All right, and Miss Underwood, did you represent Mark Ladd?
I don't have it on my schedule today. I may have in the past. Hang on. That was October what? Mr.
26th.
26th. Thank you.
All right, file number 2010-35123 DS, Brittany Coley versus Brian Myers. This is the date and time set for a show cause. Mr. Myers is ordered to pay $85 a month. As of today's date, his arrearage is $11,889.04. Last payment we received was $1,452.32 back on September 22nd of 2023. He has failed to appear. I'm going to issue a bench warrant for his arrest, and I'm going to set bond in the amount of $5,000 cash. All right. In the matter of, that's it. So we are waiting for Brandon Smith. Wasn't he going to go down and pay some money?
You said you paid $2,100.
Oh yeah. So we're waiting on him. So Miss Underwood, who else did you have this morning?
That was the only one I had on my schedule.
All right. Well, thank you.
Did we take care of Mr. McDuffie?
Oh, I guess I can do that too.
I thought it was Mr. Fry's, but.
We notified Mr. Fry. He violated bond conditions, so it's Mr. Fry's case.
Okay.
Okay.
Thank you.
Thank you.
Have a good day.
You too. Did you see the second one on the pickup list?
You have a good day too, Judge. Good morning once again, everybody. It is TCF Live, episode 346 on this glorious Monday. It's good to have you all with me. Reminder again, second session premieres today, 2:30 p.m. Eastern, 11:30 a.m. Pacific time. Our brand new show. Do join me for that. Do check it out. We will redirect at the end of this show over to that, so you can all set a reminder. Alrighty, let's go over to the thumb, Judge Prill.
People of the State of Michigan versus Shane Vern Krug, file number 267483FH. It's time and date set for arraignment. The defendant is present, represented by Attorney Kyle T. O'Mara. People are represented by Prosecuting Attorney Timothy J. Wachowski. Mr. Romero, do you acknowledge receipt of the information filed in this case? Have you and your client had the opportunity to review it? And do you waive the reading as well?
Yes, is no question, Your Honor.
Is there a plea offer at this time?
Your Honor, plea negotiations are ongoing.
All right. And as a result, are we going to have the pretrial today or?
Your Honor, we'd ask to proceed with the arraignment today. Recently, I received, I believe it was last week or late the week before, I received a significant amount of supplemental discovery. Haven't had a chance to go through that with my client. So I'd ask to just proceed with the arraignment today and schedule a pretrial approximately 30 days.
Mr. Rakowski, any objection proceeding in that fashion?
No, Your Honor.
Thank you. All right, then in light of that, Mr. Romero, on behalf of your client, as to count 1, criminal sexual conduct 4th degree, as well as count 2 and count 3, how did your client plead? Not guilty pleas will be entered on behalf of the defendant. We will schedule this matter for a pretrial in 30 days. Is McNally get a date in the meantime? Cash bond, cash surety bond, $10,000. Cash surety has been posted. Mr. Rakowski, your position on bond, please?
We have no objection to continuing bond with all the conditions that have previously been set.
Thank you. Mr. Romero? Bond will continue as previously set. September 14th, 10 a.m.
That'll be fine.
Is the Labor Day holiday. Mr. Krug, continue to stay in contact with your attorney. Continue to follow your bond conditions. We'll see you then on the 10th. September. You're all set. Thank you.
Short and sweet out of Judge Prill for that hearing, but it's a little weird. Something other than a financial crime out of Huron County. Go figure. Alrighty, Judge McNally, good morning to you.
Good morning, Your Honor.
Your name?
Kevin Robinson.
There was no accident here, right?
No, sir.
Okay, so you're gonna plead to impeding traffic, right?
Yes.
Responsible or not responsible to that?
Responsible.
All right, I'm gonna accept your plea. 160 is the total. The failure to yield's dismissed. You can go down the hall and take care of that and you're all set. Best of luck.
Thank you, Your Honor.
You're welcome. Angelina Burke, 26 W843318. Good morning to you. Your name? So you're going to plead to impeding traffic, right? Responsible or not responsible to that? Oh, you're a New Year's baby, eh? 150 is your total. You're all set. I'll accept the plea, dismiss the speed. Good luck. You're welcome. Isaiah Moss, 267843774. Your name?
Morning, my name is Isaiah Moss.
You're going to plead to impeding traffic, right?
That's correct.
Responsible or not responsible to that?
Responsible.
Plea is accepted. 150. It says you need time to pay. How much do you have today?
How much? You gave me how much?
I'm sorry?
I said you gave me how much? You said how much I have today, you said?
Yeah.
How much I had, like $500 or so?
Well, it says you need time to pay.
Oh.
I thought if you got $500, you can pay it all today, right? Total's 150.
150.
You can pay it then.
Yes.
Okay.
And I got something to tell you, Judge. Can you please reduce the fine and give me 30 days to pay because I just got a job, and please.
Wait a second. You just told me you had $500, right? Am I missing something here?
No, Judge. No, Judge. This is my first time doing this. Can you please
slow down? Why are you reading? Just talk to me. Just talk.
Can you please reduce the fine?
No, I can't do that. If I do that for you, I have to do it for everybody else.
I just got a job and I should be 30 days notice.
Am I missing something? Did you not just tell me you have $500 with you?
No, sir.
You didn't say that?
I did say yes, but this is my first time.
Do you have $500 with you?
That's in my bank account, man, sir.
Okay, how much do you think you can pay toward this today?
150, 150, Judge.
You're confusing me. You're asking me for time to pay, but you told me you can pay 150 and that's what the fine is.
I'm sorry, Judge, this is my first time doing this. And I was confusing when you asked me how much I pay.
Okay. How much money do you have that you can pay toward this today? I can give you time if you really need time, but it sounds like you had the money with you. That's why I'm asking.
Are you asking me how much money I got in my bank account, Judge? I don't have any money, sir.
Can you pay 50 per week starting next Monday?
Yes, sir.
All right. Pay $50 each week. Beginning beginning August the 10th. That's a week from today. If you don't have the money, it's not a problem. You call the court, you go on Zoom, you have to initiate the call on or before the due date, and I'll be glad to give you an extension, okay?
Yes, sir, Judge.
All right, wish you well. Good luck.
I'm sorry, I understand what you're saying.
That's okay.
I was thinking this is my first time and my parents are not here, so.
Okay, that's all right.
And if you said I gotta pay, like you said, August 10th?
$50 per week, starting next Monday, August the 10th.
Thank you, sir.
Have a great day. Ricardo Perez. 2678-42985.
Good morning, Your Honor.
Your name?
Ricardo Perez?
You're going to plead the prohibited parking, right?
Yes, sir.
Responsible or not responsible to that?
Capital?
No, responsible or not?
Yes.
Oh, that's all right. I'll accept the plea dismissed to no proof, $85. Can you pay that today? $40 due now, balance by August the 17th. If you need more time, call the court. I'll give you an extension, okay?
Yes, sir.
Good luck. Thank you. Bosman, Austin, Zane, Bosman, 26 to B 151-226. Good morning. Your name?
Austin.
What's your last name?
Austin.
All right, sir, you his brother?
No, I'm honest.
Okay.
I appreciate it.
All right, so you're gonna plead responsible to impeding traffic, is that right?
Yes, sir.
All right, to that charge, responsible or not responsible?
Responsible.
How fast were you going? Why were you driving so fast?
I was attempting to pass the car. I was plugging my phone.
You're gonna mar your good-looking face, you keep driving like that, okay? Slow down. 150 is your total. I'll dismiss the speeding. You're all set. Slow down, please, okay? Good luck. Thanks for coming, sir. Let's just wasn't missing. Better get with fix that. I was like, so boom, yeah, good call. Yeah. I don't know. The road shop 78. Wow. Yeah. Yeah. 84. Stink. All right. Therese Swatowski McKay. 266-48927. Good morning. Your name?
Charice was all okay.
All right, so you're going to plead responsible to impeding traffic, correct? To that charge, responsible or not responsible?
Responsible.
Okay, I'm gonna accept your plea, dismiss the speeding, 150 is your total. You can go down to the cashier and you're all set. Best of luck. You're welcome. John Taylor, 26W843. Seven one one, and then I have another one, 26W84375 Your name?
John Taylor.
What happened? You get cited for two?
Yeah, 2 within 24 hours. I didn't know there was no parking. All the same.
All right, so you're gonna plead on the one, they're going to dismiss the other, right?
Correct.
On the incident 26W84371 from the 9th of July, responsible or not responsible? You plead responsible?
Yes.
Please accept the original charges. I'll accept that plea, $85, and I'm dismissing on motion of the Department Rep file 26W84375. So you can go down the hall and take care of that, and you're all set. Good luck.
Thank you.
You're welcome. People against Katie Fields. Katie Fields, 26T 648945. A and B, your name. So you're gonna plead on the no insurance count 2, you're gonna plead on count 1, the failure to yield. There was not an accident, right? To that charge of failure to yield on count 1, responsible or not responsible? And as to count 2, no proof of insurance, responsible or not responsible?
Responsible.
All right. All right, I'll accept those, please. Do you have the insurance now?
No, I haven't been driving that vehicle.
I cannot drive without insurance. I'm telling you, you'll live to regret that. You get in an accident, the insurance company will pay their insured and they'll come after you for decades. I'm serious about that. 135 on the first charge, 185 on the no insurance. You owe the court $320. Can you pay all of that today? How much can you pay today?
That's the lowest I can pay.
Where do you work at?
Yeah, we're getting fumes on this. Want to take the points?
Oh, wait a minute. They didn't, you weren't gonna plead to impede fair to yield. You're pleading to impeding, right? Impeding and no proof of insurance. I wondered why they was looking at that. That was my mistake. So on count 1, to impeding, responsible or not responsible?
Responsible.
Okay, I'm gonna accept that plea. That's 150, and then I'll accept the plea to no insurance. 185. Oof. You're a bus driver and you're driving around without insurance?
I'm not now, but I will.
How much do you have today? Okay, all right. When can you pay the other 100 on the failure to yield? Can you pay that by August 17th?
Next, whatever next Friday is, that's when I get paid, so this, not from
That-
Friday, but next.
That would be the 14th, so you can pay by the 17th.
Yeah.
50 today on 945A, that'll leave you with a balance of 100 you have to pay on August the 17th. And on the no insurance, I can have you pay that in full, that's 185 by August 31, is that good? Yes?
Yes.
If you don't have the money, call the corporate, go on Zoom, I'll give you an extension, or you can walk up here on or before the due date or what have you, and I'll give you an extension, okay?
So I just go to them.
Right down to the cashier now.
Okay.
Okay? Good luck. All right. Akhil Nadavalapil, Shine, 26B151205. I probably didn't do too good on that name, did I? Did I? What's your name?
Akhil.
All right, so you're gonna plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Plea is accepted, speeds dismissed, 150, you're all set. Cashier into the hall to your right, okay? Good luck. Mary Evelyn Liberadsky, 260F2466596. Good morning, ma'am. How are you?
Nervous.
What's that?
Nervous. Are you?
Why are you nervous?
I don't look for it.
I'm a nice guy, though.
Hope so.
What's your name?
Mary.
Mary what?
Liberadsky.
All right. You all right? Okay, so you're gonna plead responsible to impeding traffic, right?
Right.
Responsible or not responsible to that? Okay, I'm gonna accept your plea. 150 is your total and you're all set, okay?
Can't pay that today.
How much do you have today? Anything?
$50
And when can you pay the rest?
next month. I only receive funds every month.
9? You could pay that on 9/7, September 7.
Put me on account for 30 days on this Saturday.
You pay 50 today and I'll make the rest due by September 14th, okay? And if you need more time, you call the court. We can go on Zoom or you can come up here and I'll give you an extension, okay? Best of luck to you. Thank you. Have a great day.
It's TCF Live on a glorious, glorious Monday. I hope you're all having a good day. I know I am. So the Winter asks in the chat, so TCF Dan, what exactly is Second Session? Second Session is our new show that debuts today, 2:30 p.m. Eastern, 11:30 a.m. Pacific. It is going to be more court content presented differently from what you see during the morning show. So it is not Morning Show Part 2, but a brand new show. I encourage you all to check it out, and you'll see when you get there. I think you'll enjoy it. Okie dokie, let's go down to Florida. Wade Mercer.
Tamika Brunson and Melissa Harrison. Miss Brunson is on my left and your right. Miss Harrison's the opposite. Ladies, I'm seeing you at the same time because your cases are identical for first appearance purposes. Each of you were first appeared this weekend for violation of probation allegations, and in each case you have no bond. What they didn't do this weekend, which I'm about to do, is arraign you. What that means is I'm going to just advise you what you've been accused of, which I just did, violation of probation, and I'm going to appoint you an attorney if you'd like to have an attorney appointed so we can get an attorney working on your case. Ms. Brunson, would you like to have an attorney appointed to represent you?
Yes, sir, but I got something to say.
I'm going to give you a chance to ask questions once we get an attorney appointed, okay? Ms. Harrison, you want to have an attorney appointed to represent you?
Yes.
I'm going to appoint the public defender's office to represent both of you. Listen to Mr. McDaniel, and then we'll see if you have any questions. Mr. McDaniel?
Your Honor, we're going to enter a plea of not guilty. Yes, set this on the September 3rd court docket, and I'm advising both an attorney to come by and speak to them about their case in the public defender's office before that hearing. Thank you, Your Honor.
Thank you. Ms. Brunson, do you have any questions? Any questions, Ms. Brunson?
Man, I don't know. I just talked to my mama. This shit is fucking crazy. I've been doing everything. She the one went up there.
Yeah, you can't use that kind of language in court. If you want to keep talking further, you can't use that kind of language. Do you have any questions? You need to talk to your attorney in private, but if you have a question, if it's one I can answer, I'll try. Do you have any questions?
I lost my job now because she was mad and went up there to my probation officer. Talking about a drug test.
Yeah, the allegations are refused to submit to your analysis. I don't know how that's your mother's fault, ma'am. You just need to talk to the attorney in private, okay? Ms. Harrison, did you have any questions? No question, Ms. Harrison. We do have two people that have friends or family here, Mr. McDaniel. The first one on the list that has friends or family is Rodney Hicks. Mr. Hicks, good morning, Mr. Hicks. You're here because you've been accused of violation of an injunction against repeat violence. Mr. Hicks, there is probable cause in the complaint. Your fiance is in the courtroom. The problem is, Mr. Hicks, that you're already out on bond in 26392 CF. I'm going to listen to the attorneys and I'm going to address your bond status. The young lady that was in the courtroom, do you know where she went? She was here on that case.
She may have gone down there. They have the injunction.
She's on the phone. All right. So, Mr. McDaniel, anything on behalf of Mr. Hicks?
Your Honor, yeah, they had the injunction here this morning. I think it's scheduled for 8:30. And Your Honor, it's a case where it was a temporary injunction that was entered, Your Honor. And
the parties live in the same trailer park, and I don't know if any of that was addressed or not, you know. They live at separate residences on the same trailer park. He called the police multiple times, I think, about people that were beating on his door. And I think during the process of that, they arrested him because they said he was living within, 500 feet of her residence, which I think his was, I've been told, somewhere around 360 feet from where it was not clear in the complaint, but, actually, but it was, I've been told by him that it was 360 feet. They told him. It's a, interesting case, Your Honor. I mean, I don't think his intent was, he called the police that he was, obviously not trying to violate the injunction.
Let me take a look at the temporary injunction, Mr. McDaniel.
Yes, Your Honor.
Let's see how it's worded.
Get it. So yeah, I was kind of curious of whether they addressed any of those issues in it.
Normally, they would clarify that kind of stuff at the court hearing, not in the temporary.
Yeah.
Normally the temporary just gives a footage. Respondent shall not go to, in, or within 500 feet of petitioner's current residence, and it gives the address 5720G. And then this incident happened at the same address, but it was it's a mobile home park. So it's a mobile home park, is that right, ma'am, in the courtroom? Okay, it's two different homes in the mobile home park.
Like I'm on one side, I'm D, and I guess she's G, and my twin would be F. They're like, we're all in one team.
Okay, so from reading I read both complaints this morning, the one he's already out on bond for and the current complaint. And your sister is the alleged victim in both cases, right?
Apparently, but there was nobody ever.
Okay, I'm just asking if she's the alleged victim. Alleged means supposed. It doesn't mean she, okay. So my question for you is, did he live with you prior to the first incident?
Been living with me since I came home from off life support in January.
Did he live with you when the injunction was entered?
Yes.
Okay. So Mr. Mitchell, anything from the state?
Your Honor, I made mention to what the alleged victim here is saying about these reports coming in. I sent the message also of what she said to both you, me, and John. If you want to take a look at the messages very quick.
What she sent, who sent to?
What she said to me.
She said nothing to me that I know of.
She said it to me, and I just said it to you two.
And Jake, I don't know if she knows if they're false reports. I mean, if his fiance is calling the police because someone's banging on the door, I don't think anyone is saying it's necessarily her banging on the door. I mean, that's not necessarily means a fake reports.
Nonetheless, yeah. Nonetheless, while this case is pending, we're asking absolutely no contact between the two of them through any way, whether it be third parties, and we ask that his bond be revoked in the felony case.
Okay. Ma'am, you're the alleged victim in both cases, right?
Yes, right. Yeah.
I'm not going to get into the details of what happened, but if there's something you think I need to know, I'm glad to listen to you.
Yes, sir.
Okay, come on up, because he needs to hear you too. So what I'm probably going to do is I'm going to set him a bond in the new case, and I'm going to order that he be held with no bond until he sees Judge Garcia in the other case. And here's why. Judge Garcia is not only the presiding judge in the case he's on bond for, Judge Garcia is also the judge in the injunction. So Judge Garcia will be the one to decide if she's going to revoke the bond. I'm just going to hold him, most likely, until he sees her. Now, any questions you have or anything you think I need to know?
The reason why he got picked up yesterday was 5:30 in the morning. I got the police banging at my door, and y'all could subpoena the officer, or
I read the complaint. Yes, ma'am.
Pick the report up where they both, Rodney Hicks and Jennifer Sontrop, both stated that it was the sister Tina, and they gave them my address.
That's not what the complaint says. Okay, the complaint says that your sister says she didn't know who it was beating on the door, specifically says that. Let me just tell you what the complaint says, okay? Because you may have
Why
got
would
some.
they show up at my house?
Well, listen to me just a second. Wait just a second, I'll read it to you, okay? Well, actually, it does say that.
Thank you.
What it says is, upon arrival, I made contact with Jennifer Sontrop, that's your sister that's here, right? And Rodney Hicks, both stated they believe Jennifer's sister, Tina Knight,
Thank you. Yes.
had been at the residence kicking the back door. Rodney advised he was aware Tina had previously obtained an injunction against him and goes on to talk about that. And then, but then it says they advised her to stay away from the property if she was the person involved. So then they tell police they don't know that you were involved, but if you were the one involved, they would like you to stay away from the property. So that's what the complaint alleges. So did you and he have a relationship?
No, never. What happened is he is a narcissist, and I got other people, a narcissist, where he
Narcissist.
Yeah,
Narcissist?
whatever you want to call it, where he controls my sister.
Okay.
And she's too sick for all this mess. So we try to protect her, and then he want to, show his true colors and try to do all this stuff, which I got witnesses out in the parking lot where he has made statements of they're going to do everything they can to try to hinder me and all this stuff, which it don't faze me. If I got to stand against him alone, I will face that man alone through this whole journey.
Okay. Let me ask a question from the jail. Corporal, I'm been told that the injunction hearing is this morning. I'm looking for it.
It's at 9:00.
And is that in person, Corporal? Is he appearing from the jail or is he going over in person?
Most likely he'll be appearing from the jail. This is the first we've heard of it, only because we didn't get the docket, or we got a docket last week and he wasn't in jail, so we had him on the out of custody. I'll recheck it here in just a little bit.
Okay. Thank you for being here, ma'am. So what I'm going to do is what I said. Mr. Mitchell, anything else? You can have a seat.
No, Your Honor.
I'm going to go ahead and set your bond to the new case because I think you're entitled to one. Your bond on the violation of injunction charge is $5,000 cash or surety. You have a condition of absolutely no contact with the alleged victim. Don't try to post the bond because it's possible Judge Garcia will revoke your bond. She's the one that reviewed the initial injunction, and she's also the judge in the felony case. So when you see Judge Garcia this morning, we need to make sure she's aware of that, of what I'm doing this morning. So James, just make sure she's aware of what I'm doing so she can decide whatever she wants to decide.
I think I got paper on my desk.
Okay. Well, James, Deputy Spates thinks it may have got continued. When were you served with the, the only way it would be continued usually is if, I think she's at the judges conference, isn't she?
No.
In the circuit judge conference this week?
No, she's got
That's
court
next
tomorrow.
week.
Yeah.
That's next week. Mr. McDaniel?
I don't know anything. I mean, he got served, I want to say July 22nd, if I recall my recollections correct. So he's been served. Whether she's here or not, I'm not sure.
Is it your understanding the injunction hearing is this morning, ma'am?
Yes, sir. It's on the table.
Okay. So we think the injunction hearing is this morning. If it's not, I'm gonna bring you back up in just a few minutes, but I want you to see Judge Garcia. So let Judge Garcia know that you're being held right now. I'm not revoking your bond. I'm just holding you until you see her. Basically, I'm temporarily revoking your bond until you see Judge Garcia. It is this morning, right, Deputy Spates?
Yes, sir, it is.
Okay. Any questions, Mr. Hicks?
That's right. All right. So.
All right. Ladies, do you have any questions in the courtroom? Ma'am, over here, do you have any questions? In the back, any questions? All right, y'all have a good day. Yeah, we do need to give him a court date for the misdemeanor case, which would be when?
31st.
August 31st be the court date for the misdemeanor case, and that'll be at 9:00. No, ma'am. She's in the other courtroom at 9:00. That's when that one's supposed to start. Okay.
Well, we're between people. Lindsay, thank you for gifting 10 memberships. I very much appreciate that. Thank you so much.
You're talking. Did y'all get that court date for him, August 31st at 9:00?
Yes, Your Honor. Yes, sir.
Thank you. Laura Odom is the next one that has friends or family here. Miss Odom, good morning. Miss Odom, your husband is in the courtroom, ma'am. You're here because you've been accused of one count of driving under the influence. Miss Odom, I've read the complaint. Ma'am, there is probable cause. It looks like you have no prior criminal history anywhere. Is that correct?
Yes, sir. That's correct.
Perfect. Ms. Odom, I'm going to appoint the public defender's office to represent you, ma'am. Please listen to Mr. McDaniel.
Y'all really asked for a cash bond in this, Your Honor. She's local. She works at Sunland, been there for a long time. I've also advised her she's going to go by the probation office and maybe talk with them about, what all she needs to do to go about getting her driver's license, some kind of work permit completed. So expect her to come by the office sometime today.
Thank you. Mr. Mitchell?
No objection to a cash bond.
Ms. Odom, your bond's gonna be $250 cash. I'm gonna offer you a conditional release. I understand you're gonna accept the cash bond. That's perfectly okay. It's a $250 cash bond. You have a condition. The standard conditions of every bond, which are don't miss any court dates, don't be charged with any crimes. And because you're accused of an alcohol-related DUI, you have a condition not to possess or consume alcohol. You cannot possess or consume alcohol while this case is pending, Ms. Odom, because of your charge. So, sir, what that means is this. I'm talking to your husband now. As soon as the $250 cash is posted at the jail, she'll be released. At the jail is where you post the cash bond, $250. The jail's also going to give her a written notice for her court date. Her court date will be August 31st at 9 a.m. in this courtroom. So that's what she's got to do. She can't be drinking at all. She's got to stay out of trouble and not miss her court date. Do you have any questions, sir? No, sir. So you can pick her up at the jail anytime you wish with the $250 cash. Okay. Do you have any questions, Ms. Odom?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
Yes, ma'am. Ryan Barrington. Barrington, good morning. Mr. Barrington, you're here because you're accused of violating your probation in 26-78 CT. Mr. Barrington, I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Barrington. He's going to admit that he violated his probation. Understanding he's going to be sentenced to 60 days in jail, 5 days jail credits, any remaining fine and costs to be added to it. Hopefully he'll work him off while he's in trustee bay. That'll resolve this case.
Did you say 5 days credit?
Yes, Your Honor.
Mr. Gibson? So he had already paid his fine and his public service work. I don't know if you can hear that, but Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Mr. Barrington, did you hear that agreement?
Yes, sir.
Any questions about that agreement?
Yes, sir.
Is that the plea you would like to enter, the admission you would like to enter, sir?
Yes, sir.
So how long has he been on supervision?
6 months.
Mr. McDaniel, Mr. Mitchell, I was not aware of that he had already paid his fines, because that means he's paid $1,400 called supervision and fines. What's he paid?
$500 for total service work. He paid $1,078 for this court costs. He paid $240 for 6 months of probation.
Almost $1,800. Is this the only criminal charge you've ever had, Mr. Barrington?
Yes, sir.
And the violation was allegedly consuming alcohol, and they didn't report. You told him to come in, then he had a medical event the following day, right, Mr. Goodson? Mr. Mitchell, what's the state's thoughts about 30 days instead of 60?
We're not going to object to that.
Mr. McDaniel, given that he's paid over $1,800 and he did 6 months without violating, I think that may be a more appropriate sentence. I think when I offered the 60, I was the tentative offer that I suggested. I was not really fully aware of the circumstances. Mr. Mitchell seems to be in agreement with that. So if you're okay with that, that's what we'll do.
Yes, Your Honor.
Mr. Barrington, if you enter this admission, I'm going to sentence you to 30 days in jail, not 60, based upon what you did get completed. Still not going to be on probation anymore. Still going to revoke it. Still going to sentence you to a jail sentence, but it's half the time of what the tentative original agreement was. Mr. Barrington, is that the admission you would like to enter?
Yes, sir.
I'm going to accept your admission that you violated the terms and conditions of your supervision, revoke that supervision, and sentence you to 30 days in jail. You've already paid your court costs and fines. You've got credit for 5 days that you've already served. So when you finish the 25 days you have left, you'll be through with this case. You may have to do a little less than that under Florida's game time law, but that's between you and the jail. I can't promise you that. That's tied to your behavior at the jail. Any questions, sir?
No, sir.
Wish you the best, Mr. Barrington.
Thank you, sir.
Yes, sir. We have James Wines. Mr. Wines, come on up. Mr. Wines, you were first appeared this weekend. Looks like the judge set your bond on a new charge here, and you also had a holdout of Bay County. You're being brought back today to try to see if we can resolve the charge here. I'm appointing the public defender's office to represent you in the driving while license suspended case. Please listen to your attorney, Mr. McDaniel.
Your Honor, Mr. Wines, it's hard to hear, so I'm going to try to speak up a little bit. He's going to enter a plea of no contest to the charge as listed. You understanding? He'll be sentenced to 6 months in jail. You have 3 days jail credits. You have $400 fine. He has waived his right to a jury trial and call witnesses. This will resolve this case today.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Wines, did you hear that agreement?
Yes, sir.
Mr. Wines, do you have any questions about that agreement?
No, sir.
Is that the plea you would like to enter, sir?
Yes, sir.
Mr. Wines, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly. The judge who guilty of that offense sentenced you to 6 months in the Jackson County Jail based upon your numerous priors. Thank you. Court costs and fines are imposed the amount of $400 to give you 3 days credit. Mr. McDaniel, do you want that standard language put in there that you normally request about not being used against him in VOP proceedings?
Yes, Your Honor.
Mr. Wines, there's going to be a condition put on this disposition that says they can't use this plea today against you. Now, they can still use whatever happened last week. They can use the incident. They can call witnesses, but they can't just introduce what you're doing today to use that to violate your probation in Bay County. I think it's a probation case down there. So, Mr. Wines, what's going to happen is if they get down there and they try to use that against you, what you're doing today, that is, I will let you withdraw this plea. I've never had that happen. Usually they don't do that. But, Mr. Wines, what's going to happen is you're going to commence this sentence here. Hopefully, you're going to get in the trustee program, I hope, and get you some extra gain time. And when you get near the completion of this sentence, you get it down to a week or 10 days, somewhere in that neighborhood, they're going to contact Bay County and see if Bay County still wants you. If Bay County still wants you, Bay County will come and get you, and you may actually serve the last few days or a couple of weeks of your sentence in the Bay County jail while you're dealing with that allegation down there. Mr. Wines, do you have any questions, sir?
No, sir. Thank you.
Yes, sir. Wish you the best, Mr. Wines. Mr. McDaniel, that's everything I had on my list, unless I missed somebody.
That's all I got, Your Honor.
So, anything else from the public defender's office?
No, Your Honor.
Corporal, Mr.
All right, that's it for Judge Mercer this morning. Let's go to Lake County, Ohio. Judge Culotta. Say good morning to him.
All right. We are here in case 26 CR 089, State of Ohio versus Joseph Gaston Jr. Here for a pretrial. You're Mr. Gaston?
Yes.
Mr. Gaston is present, represented by counsel Mr. William Watson. And the State of Ohio is represented by Special Assistant Prosecuting Attorney, Mr. James Dugan. Mr. Dugan, can you just give me a brief summary of what this is all about?
Sure, Your Honor. New Year's this year, and Mr. Gaston and the victim, Victoria Cantrell, at an apartment on Corwin Drive in Painesville, drinking beer, drank too much beer, got into an argument. In the course of the argument, Mr. Gaston forced Mrs. Cantrell to the ground. Her ankle was fractured in a number of places. Her testimony will be that he was using a pillow to try and suffocate her, was pinching her nose, trying to cover her mouth. She scratched him pretty good to get up, and he went to neighbor calls 911, police come. In the interim, Ms. Cantrell had started a fire.
Ms. Cantrell did what?
Started a fire in the apartment, at least that's the allegation. And I believe that's why I'm involved. She's been indicted, she's incarcerated.
So she's got charges against her?
Yes.
From the same incident, but sort of like after the incident?
Yes.
Gotcha.
That's right. And Mr. Gaston has 4 prior convictions for domestic violence.
So that's why it's a felony of 3rd degree?
Yes.
All right, thank you. Has discovery been provided?
Yes.
Is there an offer being made at this time in terms of a plea offer?
We haven't had a chance to talk with him, but the offer would be to plead at least to felony 4, domestic violence.
Is that been conveyed, that's being conveyed right now, basically?
Right now, yes. Mhm.
I didn't mean to say you had to make an offer, I'm just was wondering, I didn't want you to interpret it that way.
Understood.
All right, Mr. Watson, anything you'd like to add at this point here?
Just that, Your Honor, I did in fact receive discovery. I have been in contact with my client. He's obviously here today. I would like to speak to Mr. Dugan after this pretrial. It is true we haven't had an opportunity to speak. In fact, this is the first time we've met. We just introduced ourselves. So
he's a nice guy.
He seems like it, Your Honor. So just like a brief opportunity for that, I'm sure we'll come up with a resolution prior to trial. Thank you.
Well, you don't have. I'm not trying to force that on anybody. It's just that's between you guys. Any suppression issues here?
No, Your Honor.
Is the prosecutor's office representing the state in the arson charges?
Yes.
Okay.
Mm-hmm.
All right. So, Mr. Gaston, you are released on a known recognizance bond, which means you didn't have to post any money. You signed some paper, and your signature was your bond. But what that also means is that you have to appear at all future court dates. And if you fail to appear at any court date when you're released on a known recognizance bond, that's a separate felony that you can be prosecuted for, and you can get up to 18 months in prison, separate from anything that could happen with the charges here. So it's obviously important you show up at all future court dates.
Yes, Your Honor.
Now, your next court date is the trial in this case, which is set for September 22nd. So if this case is going to be a trial, it'll be September 22nd. If the case gets resolved with some type of plea negotiation, which we heard that they were talking about, and you come in and plead guilty to some charge, that will be before the trial date. It will be before September 22nd. Now, the court has to be notified 2 weeks before that, at the latest, so that would be September 8th. Your attorney would have to notify the court that you're going to enter a plea of guilty to some charges, if you're going to do that. You can do it, well, you can do it before September 8th, but after September 8th, I won't accept it. That won't be accepted. If that's how this case gets resolved, a hearing will be scheduled before September 22nd for you to come in and enter your plea. Now, obviously, I don't know if that's going to happen, and I don't know what date that would be because I haven't been notified that's what's going to happen. But I need to make sure you understand that it will be before September 22nd, and it's your obligation to make sure you know when that date is.
Yes, Your Honor.
So after you meet with your lawyer, if you decide you want to enter a plea of guilty, your lawyer will let you know when that date is. But if you don't hear from him, you need to reach out to him. You can call the court. You can go online and look, but it's your obligation to make sure you know when that date is. It'll be before the 22nd of September. You understand that?
Yes, Your Honor.
All right. Do we have all your current information in terms of where you're living and your phone number, or your
Yes,
attorney
Your Honor.
does?
Yes, Your Honor.
Okay. All right. Very good then. Mr. Dugan, anything else for the record at this point?
No, Your Honor. Thank you.
Mr. Watson?
Nothing further, Your Honor.
All right. Thank you both.
Alrighty, friends, hour 2 now of TCF Live on this Monday, episode 346 today. Good to have you all with me. Let's go back to Huron County, Michigan, Judge Prill.
8, it's time and date set for arraignment. Mr. Phillips is present, represented by Attorney Michael A. Morosky. People are represented by Prosecuting Attorney Timothy J. Rakowski. Mr. Morosky, again, have you received a copy of the information filed in this case? Have you and your client had the opportunity to review it? You waive the reading as well.
Yes to all of the questions, and Mr. Phillips will be tendering a plea here today.
Very well. Mr. Phillips, as best you can, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Put down. Mr. Rakowski, would you please state the terms of the plea offer on the record?
Your Honor, Mr. Phillips would be pleading guilty to resisting obstructing a police officer without any habitual offender notice. People would agree to dismiss count 2, the disorderly drunk count, and Mr. Phillips would agree to pay full restitution if it was applicable.
Thank you. Mr. Morosky, is that your understanding of the plea offer?
Yes, Your Honor.
Mr. Phillips, did you hear the terms of the plea offer outlined a moment ago?
Yes, Your Honor.
Is that your understanding of the plea offer?
Yes, Your Honor.
Do you wish to accept it?
Yes, Your Honor.
Are there any other terms to the plea offer that we've not covered on this record?
No, Your Honor.
Mr. Morosky, do you agree?
I agree, Your Honor.
Mr. Rakowski?
I agree, Your Honor.
Mr. Phillips, are you on any term of probation or parole?
No, Your Honor.
Have you had sufficient time to speak with Mr. Morosky about this?
Yes, Your Honor.
Do you need any additional time to speak?
No, Your Honor.
Is there anything affecting your mind or brain making it difficult to make important decisions?
No, Your Honor.
You have a clear mind?
Yes, Your Honor.
Mr. Phillips, you're charged in the information with resisting or obstructing a police officer. That is a felony carrying a maximum prison sentence of up to 2 years and or a fine of up to $2,000. You understand the charge and maximum sentence can be imposed?
Yes, Your Honor.
Understanding that then, sir, how do you plead to the charge contained in the information alleging on or about June 26th, 2026 in the city of Bad Axe, County of Huron, you committed the offense of assaulting, resisting, or obstructing a police officer?
Yes, Your Honor.
Guilty? All right. The court is in receipt of an advice of rights form. It's dated August 2nd, 2026, which would have been yesterday. Has a signature, which the court can read clearly, is Brian Phillips, with an address. Mr. Phillips, you signed this document?
Yes, Your Honor.
Now, before signing it, did you read it over?
Yes, Your Honor.
Did you also go over it with Mr. Morosky?
I did, Your Honor.
Do you understand the rights contained on the form?
Yes, I do, Your Honor.
By pleading guilty, you're giving up those rights.
Yes, Your Honor.
That means you will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. And all that remains after today will be for you to be sentenced.
I understand, Your Honor.
If your plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice.
I understand, Your Honor.
Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to get you guilty?
No, Your Honor.
Understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise that the court will be easy on you in imposing sentence. Understand that?
Yes, Your Honor.
Does anyone promise the court will be easy?
No, Your Honor.
Does anyone threaten you to enter this court?
No, Your Honor.
It's your own free choice.
Yes, Your Honor.
Court costs are due and payable at time of sentencing unless there's good cause shown. Are you aware of that, sir?
Yes, Your Honor.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence.
Yes, Your Honor.
Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this plea will be by application for leave to appeal and not by right.
Yes, Your Honor.
Mr. Phillips, any questions regarding any of your rights?
No, Your Honor.
Any questions of your attorney, Mr. Morosky?
No, Your Honor.
Thank you. Back on June 26, 2026, were you in the city of Bad Axe, Huron County, Michigan?
Yes, Your Honor.
At the time, did you make contact with an individual identified as Nathaniel Flores?
I did, Your Honor.
Is he a police officer?
Yes, Your Honor.
Was he in full uniform?
Yes, Your Honor.
Was he working for the Bad Axe Police Department performing his duties?
Yes, Your Honor.
And what makes you feel that you're guilty of assaulting, resisting, or obstructing?
I was disobeying an order, Your Honor.
What was the order?
I was disobeying to obtain an order of being
Let me help you out. I have no idea, but Sergeant Flores approached you.
Yes, Your Honor.
He asked you to do something,
Yes, Your Honor.
something that would be in his duties as a police officer.
Yes, Your Honor.
And did you comply with his order?
I did not, Your Honor.
Any objection to the factual basis?
No, Your Honor.
Mr. Rakowski, you aware of any promises, threats, or inducements for this plea other than what's been disclosed?
No, Your Honor.
Mr. Morosky?
No, Your Honor.
Has the court complied with the court rule concerning pleas, Mr. Rakowski?
It has, Your Honor.
Mr. Morosky?
It has.
Mr. Phillips, there's been no agreement made by this court concerning the plea and what the final result will be. Is that accurate?
That's accurate, Your Honor.
Mr. Morosky, do you agree?
I agree, Your Honor.
And Mr. Rakowski?
I agree, Your Honor.
Thank you. The court will accept the plea. It's done freely. It's voluntary. It's understanding and accurate. There's a sufficient factual basis. The court will accept the plea and schedule sentencing for.
Your Honor, we have a calendar motion through September. Is there a motion dated for September, the first motion in October?
Well, yes, we'll be here. October 5 is what you're
Yes, Your
requesting.
Honor.
Mr. Morosky, is that an acceptable date?
Yes, Your Honor.
Court will schedule sentencing October 5, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation report to be prepared, provided to both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines scoring shall be provided to counsel and the court no later than 14 days from sentencing. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing, and to the probation department. And if there's any supporting documentation either party wishes to submit, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set at $3,500, 10%, but it's not been posted. Mr. Morosky, what's your position on bond?
We ask that bond be continued.
Mr. Workowski, any comment?
We have no objection to bond continuing.
Bond will continue as previously said. All right. We'll see you then on October 5th. Thank you. You're welcome. Awesome.
Thank you.
You're welcome.
Alrighty, good morning once again, everybody. Episode 346 of TCF Live. My name is Dan. It is good to have you here with me today. Worth noting, courtroomfiles.com, you will find a brand new line of merchandise, the Courtlandia Travel Bureau line of merch. Do check that out. We put some pretty cool stuff up there, some wonderful designs, so do check that out. And reminder, members, you get 20% off. The code for that is in your member information on the YouTube members page. Alrighty, let's go. It's time to go to Texas. Judge West, the Monday Morning Fashion Show.
I'm saying it's better than other things I've been called. Good morning. Are you Paul Malone?
Yes.
Come on up. Sherman Malone, did you get someone hired?
No, man, but I called several.
Who'd you talk to?
I'm with this.
Just
number.
tell me who you talked to.
Oh, I talked to Miss Holmes, Brittany Holmes, and she was $3,500. I talked to Jason Nix. He wanted $100 just to come talk to me. I just can't do that. Kelly Gertz, which they said they were gonna call me back, never did. William Hall, pardon. He told me I needed to hire my previous lawyer because they would know more about it, which was Miss Holmes. And then James R. Macon, and he's $7,500. And Corey Crenshaw was $7,500 as well. And they wanted like $3,500 down.
Right. Are you working?
Yes, ma'am. But to be honest, I'm not getting many hours because I can't go out of the county.
Okay.
I was hoping that maybe you could.
Well, what I'm going to do this morning, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
If you step in front of the clerk all the way on the end, she'll give you that paperwork.
Ask you one question.
What's that?
Is there any way that I can go out of the county for my GPS just during work hours?
Let's do this first and then remind me in just a minute. Y'all keep make a note of that. I'll look at it. Yes, sir. Jacqueline Calloway. Good morning. Are you Jacqueline Calloway?
Yes, ma'am.
And Mr. Calloway, this is your initial appearance in cause number 26 DCCR 0898. You're charged with the state jail felony offense of engaging in organized criminal activity, and that's from March 1st of 2026.
Yes, ma'am.
Since you made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
So what I'm going to do, since you've made bond, I expect you to try to hire someone. So I'm going to reset your case about 30 days to give you some time to do that. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me those names of who you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you go back to jail.
Yes,
Do you
ma'am.
understand? All right, step in front of the clerk and she'll give you a reset notice. Fine. Kindari Simeon. Good morning. You're Kindari Simeon?
Yes, ma'am.
And Mr. Simeon, did you get someone hired?
No, ma'am.
Who'd you talk to?
I talked to Mark D. Lambert, Brittany A. Holmes, and Williams Kelly.
Okay.
Yes, ma'am. They were charging for the 2 Mark D. Lambert, 10,000, and then for Brittany, she was about the lowest that I could find for like 5,500.
And where are you? You're working?
Yes, ma'am.
Okay, so where are you on being able to maybe get someone hired?
I'm not able to pay what they're asking right now.
Okay.
Yes, ma'am.
Where you work?
Jack in the Box, and I do like last side contracts for landscaping.
Okay, so what's the shirt you're wearing? That's not a work shirt?
Yes, ma'am. This is a work shirt.
For what job?
No, this is what I use for landscaping. I have to finish. Yes, ma'am.
Okay. All right. So I'm going to have you fill out some paperwork this morning, Mr. Simeon, to see if you qualify for a court-appointed lawyer. Thank you for doing what I asked you to do. Make sure you fill out that paperwork accurately and completely. Include any income you have, any bills you have, and then I'll take a look at
Yes,
it.
ma'am. Also, with the 30 days, can I get it to a date after I see my doctor?
Just let's do this first, okay?
Yes, ma'am.
All right. Tryvin Greer. Tryvin Greer. Mhm. Oh, Greer does. It's got A for us. No response, Your Honor. This bond will be forfeited for non-appearance and reset at 100,000. Michaela Sylvester. Good morning. For Michaela Sylvester?
Yes.
And Miss Sylvester, did you get someone hired?
No.
Who'd you talk to?
I had called Michael Ray Waltz. He didn't answer, and then I called William James called Jr. Didn't answer, and then I called Mr. Burbank. I have a meeting with him tomorrow at 3:30.
Okay. And are you working?
No.
You're not. Why aren't you working?
I haven't found a job yet. I've been searching. I've been putting applications, but no one's got back to me yet.
Okay. So Miss Sylvester, I'm going to have you fill out some paperwork this morning since you did what I asked you to see if you qualify for a court-appointed lawyer. Make sure you fill out accurately and completely because you're going to swear under oath that it's all true, and then I'll take a look at it.
Yes.
Step in front of the clerk on the end and she'll give you that paperwork. Yes, ma'am. John Doucette. Good morning, you're John Doucette.
Yeah.
And Mr. Doucette, this is your initial appearance and clause number 26 DCCR 1122. You're charged with the 3rd-degree felony offense of stalking, and that is from April 6th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Speak up, please.
I'm not.
All right, so Mr. Doucette, I'm going to reset your case for about 30 days to give you some time to try to hire a lawyer. If you hire someone before that next court date, then just bring the reset notice to them and they'll tell you what to do. If you're unable to do that, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? And I know it's a condition of your bond, and I'm sure you were made aware. I do want to make sure you understand that as a condition of your bond, you are to have no contact or communication with Ashley Doucette. You understand?
Yeah, the only communication we do is through our family wizard.
Perfect.
Back and forth.
Okay.
It only deals with the
kids.
Yes.
And so you guys, are y'all going through family court at this time?
We're getting there.
Okay, so I will approve the family wizard only also, okay? So you can use the family wizard, but no other contact or communication other than about your children through that app.
Yeah, and then our periods of drop off. We meet at a certain location.
Okay, in public.
Yes.
Okay, perfect.
And then I get them and then bring them back.
Perfect.
Yeah.
Okay, sounds good.
Standard visitation, like most people.
Well, I just want to make sure there's no issues, and so I want that to be at a public place.
Yeah,
okay,
it is.
All right, step in front of the clerk. She'll give you a reset notice. Bryson Grisecki. Good morning. You're Bryson Grisecki?
Yes, ma'am.
And Mr. Grisecki, did you get someone hired?
No, ma'am. I've been in talks with Mr. Kimler, but my only source of income right now is my carpet cleaning van, and it's been in the shop for 2 weeks. It just got out, and the same thing happened, so I had to put it back. So I'm not really making any money at the time while it's in the shop.
Okay. Have you started looking for something else to do?
Not currently, no, ma'am.
So how are you paying bills and taking care of yourself?
I have a roommate, and that's kind of he's doing that while the van's in the shop.
Look at some. All right, so I'm gonna give you a, let's be so cool. Apparently there was a warrant. I mean, this case is from back in 2024, but you weren't arrested until the
6 in March.
Did you know that there was a warrant for your arrest all that time?
I had no idea. They showed up one day at 11. I was sleeping, and they said I had a warrant, and I had no idea. Yeah, it was from 2 years ago. So I had no idea the whole time.
Okay. All right, so I'm going to give you one more reset. You need to try to get Mr. Kimler hired. If you can't, then talk to some others, bring me those names. Also, bring any type of proof you have of the income that you have with your company and or receipts from the shop that
Yeah, I have
any proof that you can get me that shows what's going on. Okay. All right, step in front of the clerk. She'll give you a reset notice. What is mythical mean on this next one?
They call. They call, you know.
Was released. Somewhere on the discharge date was last week.
Alrighty, friends. Well, they work to rack up the next contestant. Let's go across the hallway to Judge Stevens. Looks like they're wheeling in this contestant.
Just keep on coming.
26 CR 1119 is called Daryl Wayne Cooper. You're Mr. Cooper? Yeah. Is that right? All right, we've got two problems here you probably are intimately familiar with. There's a theft of property, and it's not a lot. It was a
household judge.
It was food from Walmart. Walmart. But the problem you have, I mean, looks like it was about $10. The problem that you have is because you have so many prior theft convictions, every time if you steal a pack of gum, it's a felony the rest of your life because you have so many convictions. That's the way the law works. Is prior convictions mean people who commit another crime thereafter are held more responsible than people who have not had a criminal history. Generally. So my advice, of course, is don't steal. Because every time you steal, it's a felony at the minimum. So that means you're looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you have anything about his probation that you can transform me?
Yeah, the motion that was filed yesterday, Judge.
Oh, great. Okay, let me look at that.
Not.
You're also on probation for another offense. And a motion to revoke probation was filed probably because of this theft here in this new case. So you've got two fires you've got to deal with. And you know that. Mr. Deucer's good man. He can help you navigate through this, but you're going to be held accountable. And because you have a felony, it looks like there's a felony in this court in 2010. So you're not eligible for probation anytime you commit a crime in front of a jury. We cannot give you probation. So in this other case, yeah, a motion was filed this morning to revoke your probation, and this was criminal mischief. You were placed on 5 years deferred or unadjudicated probation back in August of 24. So 2 years ago. And this motion alleges that you violated your probation by committing theft, which is represented in this new indictment, committing the offense of criminal trespass on or about May 1st of this year, failing to report to the probation office on or about May 5th. How long have you been in jail? A while? When was he put in jail?
I'm gonna say May 1st with this new theft. Was he arrested?
Was he caught in the act? Yes. It's going to be hard to report.
June 13th.
I'm sorry?
June the 13th.
Okay.
He was placed in custody.
So he was still free.
Gotcha.
He failed to report on May 5th. That was before his arrest. He's in arrears of restitution in this criminal mischief case of about $3,400.
That was the original.
Which means looks like he hadn't paid anything on the restitution since he's been placed on probation for 2 years. But you're stealing. You're committing crimes, but you're not paying what's due. So there are 5 different grounds here of violations of probation. And this is a state jail felony that you were on probation for. So you were looking at up to 2 years in the state jail. And this new case also carries with it a punishment range of up to 2 years in the state jail if found guilty. So that's 4 years in the state jail, and there's not much parole on the state jail. You've got to serve almost all of it. So that's a lot of time. So Mr. Dusler is going to I have to work with you to see if there's something that can be figured out. I'm gonna reset this until Wednesday. That'll give us 48 hours to look at it and see if there's something that can be done.
I'll get with her. I don't think I'm available on Wednesday at all.
Soon, let's have a review this week on.
But I haven't even seen the motion yet. It's just filed.
Okay, yeah, well, there's a copy here.
Okay.
Already in the file. That was filed at midnight.
That's why I haven't seen it.
Well, Mike's working late. Hey, Larry, you filed that thing at midnight. Well, you filed that motion at midnight last night. Wow, what a guy.
Around here.
Look at that. Look at him go.
That was just his internet connection, Judge.
Do you ever go home? Do you ever go home?
I was home. I was on my back patio.
Oh, I see. Oh.
Floor in the fauna.
All right. So that is what's Eric Gerard.
There's a courtroom. Thank you. It's starting off. So, that's what I thought. What? Oh, that's, you know, here's something. I used to go reasonable. He's never comes to stuff on 30 minutes.
Eric Gerard? Is that you?
Yes, sir.
Okay.
I don't know if you have this thing on.
Your attorney is here. You need to see that lady. She's going to swear you in. Thank you.
Raise your right hand. You swear or affirm the truth of the truth of God. Okay. Ink up to your right thumbprint. Place it flat right there on the box. Ink it up one more time. Place it flat right outside the box. And go to me front of the
Number call 26CR106, State of Texas versus Eric Jason Gerard, who is present, that his attorney, Mr. Dusler, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? And we proceed in summary.
Yes.
In summary, this indictment alleges, looks like there's 3 paragraphs here. An allegation of the crime of burglary of a building, and then 2 prior convictions of burglary and a second conviction of assault on a public servant committed in Jefferson County. The burglary, you were convicted in 2008 in the court next door, the 252nd District Court. After that was final, it is alleged you committed the felony of assault on a public servant. You were convicted of that in the 102nd District Court of Bowie County. It's a ways off in 2023. So paragraphs 1, 2, and 3 constitute a state jail felony, but it is punished as though it were a second-degree felony because of the prior felony. So you understand how that works. Right. So in summary, again, the state's on or about May 5th, 2026 in Jefferson County, Texas, you committed the crime of with intent to commit theft. You intentionally and knowingly concealed yourself in a building and committed burglary of a building of the Civic Center here in Beaumont. Paragraph 2 goes on to allege that on February 6, 2008, in the 252nd Judicial District of Jefferson County, Texas, next door here, you were convicted of burglary of a habitation. After that burglary of a habitation conviction was final, it is alleged that on or about May 5th, 2023, which would have been 15 years later, you committed the felony of assault on a public servant, a 3rd-degree felony, and that was a conviction in the 102nd District Court of Bowie County, Texas. So again, paragraph 1 and 2 and 3 constitute a state jail felony, though punished as though it were a second-degree felony. Do you understand how that all works?
This one, I do 40 at this point. Could be higher. I think it's fair. You have competitive.
All right, this means that you are facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range you would face?
It's sort
Agreement has been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment in paragraph 1, charging you with the state jail felony of burglary, guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And these 2 prior convictions, burglary of a habitation and assault on a public servant, as we discussed in paragraphs 2 and 3, are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence.
Okay.
Without objection, it's admitted. Among other things, this stage you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is a pre-sentence report waived?
Yes.
I'm going to follow this agreement. If nothing further to add, I'm going to find that you are pleading guilty and true to paragraphs 1, 2, and 3 respectively, which constitutes a state jail felony, burglary of a building, though punished as though it were a second-degree felony by the consecutive sentences and convictions in time, paragraphs 2 and 3. You are mentally competent to enter these pleas. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, punished though as though it were a second-degree felony because of the prior felony convictions. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And of course, you will be given credit for all time you have served in accordance with this case. You understand what has happened today, sir?
Yes, sir.
Anything else? Okay, that is fine. Thank you.
Alrighty, friends, let's change it up. Let's go back to Judge Prill and check in with him.
7448, I'm sorry, 7448 and 7449. The court took a brief recess to allow counsel the opportunity to potentially present witnesses in this case. Again, James Champion appears on behalf of the defendant who is in the courtroom. Chief Assistant Prosecuting Attorney David J. Wallace is in the courtroom as well. Mr. Wallace, have you had an opportunity to secure a witness?
Yes, Your Honor, we are ready to proceed.
All right. You may call, well, you may, if you have an opening, you may proceed in that fashion as well.
Your Honor, I'm willing to waive the opening at this point in time.
Very well. Thank you. You may call your first. Sir, would you please raise your hand?
You solemnly swear or affirm the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do. Please be seated. Mr. Wallace, you may proceed.
Thank you, Your Honor. State your name, please, and spell your last name.
Nate Flores, Flores.
And you're wearing a uniform with FedEx Police Department, you're employed there.
Yes,
Your role there is,
I'm a sergeant with the police department.
and as part of your job duties, also responsible to review and approve police reports that come in over the weekend.
That's correct.
And in fact, today, one of the things you were doing this morning was reviewing a report involving defendant Mark Roll.
Yes,
And that was involving a possible bond violation.
yes.
Now, what did you learn from that report as to what happened?
On Saturday, August 1st, just before 7:30 p.m., Chief Weber had contacted Officer Bisher, who was on duty for us that night, regarding the bond violation at the movie theater with Mark Rawl.
So Chief Weber contacted the officer. Did someone contact Chief Weber before that?
Yes.
And was that a Jason Rogers?
Yes, it was.
And did the report indicate what Mr. Rogers told the chief?
Yes, Mr. Rogers reported to Chief Weber, and then
Did Mr. Rogers also speak with the officer later on after that?
yes,
Okay.
yes,
What did Mr. Rogers report?
that he had taken his children to the movie theater Saturday night to watch a movie, and then had observed Mark Rolfe at the counter, taking tickets, getting concessions for customers.
And this was during this time, did he say how old his children were?
I believe he did. I'd have to refer to the report
To
to,
help refresh your memory?
yes. Approximately 11 years old and 14 years old.
And was there also a picture that was obtained from Mr. Rogers?
Yes. Mr. Rogers took a picture of his son holding a bucket of popcorn with Mr. Rolfe in the background taking tickets.
Was that sent then to the Maddox Police Department?
Yes.
May I approach, Your Honor? You may. Actually, I guess I should have it first. And as showing you what's been marked as proposed one, is that a copy of the image that was sent to Maddox Police Department?
Yes, it is.
Is it an accurate copy?
Yes,
Now, you didn't take a picture, obviously.
I did not.
And Mr. Rogers is the one that indicated he's the one that took the picture
Yes, sir.
and then forwarded it to the police department. And did he indicate when he took the picture approximately? Was it the same time he was there that evening?
Correct. Yes. Saturday night, roughly around 7:30, I believe.
Here, I move the admission of proposed one.
We'll stipulate.
People's one's admitted. And did the officer, Fisher, have contact with the defendant then?
Yes.
And in terms of the contact, what happened at that point?
Officer Bisher and I believe Deputy Jobs responded to the theater. They located Mr. Rolfe in an office, I believe, in the movie theater, and began to speak with him about the bond violation.
And did the defendant acknowledge the bond condition?
He did.
He was aware of it.
Yes.
Did he say why he was still there?
I believe the defendant stated that some employees didn't show up to work, and that's why he had to work the counter concessions.
Did he acknowledge to the officer that he knew there were minors there as well?
Yes.
No further questions, Your Honor.
Cross-examination.
Going,
Morning.
was Mr. Rolfe always at all times cooperative and complying with your request?
The officers on scene, I believe so, yes.
Hey, okay.
Direct?
No redirect, Your Honor.
You may step down, sir.
People have no further proofs.
Chair, do you wish to present any proofs?
No proof, Your
Your Honor, I think the testimony that the defendant, one, knew about the bond condition, two, admitted himself that there were minors there based on the picture that he admitted, like, approach the court to. Based on the picture, the court can see there, of course, the young man holding the bucket of popcorn, and you see the defendant in the background there selling more tickets. And the court, we would ask the court to take judicial notice, of course, of its own orders, which has the requirement that there be a bond the bond said that he had no contact with anyone under the age of 18. That was entered into a lien, and then that was extended as well by this court by an amended order. So it's currently until September. So we believe that the proofs are sufficient for showing that the defendant violated his bond conditions.
Mr. Champ.
Thank you, Your Honor. I suppose if my client was going to the grocery store this morning, he'd be in violation of the bond if there were people under 18. We live in a workaday world. My client owns a business. I was not his attorney when the bond was originally imposed. However, I feel somewhat responsible because I did not anticipate a situation like this. Mr. Rolfe, on the course of the weekend, was placed in a very difficult situation. I saw a movie expert say that the Odyssey and Spider-Man were a 1-2 punch, unlike anything he'd seen in 60 years at the box office. And here we have a situation where my client's employee didn't show up, the person who would normally work the counter and the concessions. And so Mr. Rolfe was placed in a very untenable situation. He's been a model citizen on bond since before I was hired back in late February. He's been on bond for almost 8 months. He's been at every hearing. He has shown every willingness to cooperate with the spirit of the bond. I can't imagine that it was anyone's intent that he would have to close his business in the situation he found himself in this weekend. But at the same time, it seems as though that if it was meant to be taken that literally, that, like I said earlier, that he couldn't be in a grocery store if there were people under 18, that he couldn't be in the theater, where his customers are. Many of them attend the movie with their parents. Even viewed in the light most favorable to the government, I don't think it could be said that Mr. Rolfe was in a position to do anything untoward to any of those customers. And I would ask the court to continue his bond. Trial is set for November. It'll be a long time to sit in jail for keeping his business running when he had no choice other than to close it down. Thank you.
Rebuttal argument?
I was just trying to provide an argument as to the hearing, whether or not there was sufficient evidence to find the defendant responsible or guilty of the violation. And I'm going to say that we still have shown that if the court finds him guilty, I do have comments in terms of possible consequence, but I hadn't gotten there yet because I was waiting for the court to make a ruling on the hearing itself. So I'll stand by my comments in the testimony to court before the court in terms of whether or not he violated the bond conditions.
Sure. Well, the court takes judicial notice of all 3 files. All 3 files indicate in part under paragraph U, not to be around anyone under the age of 18 years of age. It's in all 3 files. The original file, defendant is to have no contact with anyone under the age of 18. According to the testimony of Sergeant Nate Flores, Bad Axe Police Department, now he wasn't there, but under 1101, the court considered this for purposes of the bond hearing. On or about August 1st, this past Saturday, the defendant clearly was taking tickets at the Bad Axe Theater. And there's a photograph that's been admitted as People's Exhibit 1, which clearly indicates that, well, I should say, but testimony of Sergeant Flores, that there were children there, one age 11, one age 14. The complainant, Jason Rogers, reported this to the Bad Axe Police Department. And despite the fact that the defendant was cooperative with law enforcement, clearly it's a violation of the bond conditions. Wallace, you have a recommendation regarding disposition.
Yes, Your Honor. We were asking the court to cancel the bond. A couple things for the court's information. That was not part of the testimony, but as an officer of the court, to let the court know, and I informed Mr. Champion of this earlier this morning, before Mr. Champion was the attorney on the case, This issue came up while in district court. And Ms. Weisenbach was the attorney of record at that time. And I was contacted by a similar situation where from the Bad Axe Police Department that they had got a complaint because the defendant was, again, selling tickets at that time and there were minors present. I spoke to Ms. Weisenbach. We did not put anything on the record. There was nothing formally done. I will acknowledge that. Absolutely. But we spoke to Ms. Weisenbach to make it clear that that covered, that bond condition included at the theater. Now we come to the hearing, and as the court heard from the testimony of Mr. Flores, the defendant acknowledged, I know that I have that condition. Yes, there are minors here present. This isn't some chance occurrence. It's a theater where children are coming. And so we submit that there had been a blatant violation here, the acknowledgement that he knew he had to do it. And he cited, well, I'm going to chance it, I guess, is almost sort of the attitude here. And we don't think that should be allowed. So we're asking that the court cancel the bond. And we had a case, I know it hasn't been put on the record yet, but I know that there was a stipulation that the trial was adjourned until November. So I don't know, counsel's going to give a stipulation and just sort of as a reference reminder to get that to us. But other than that, so I know that that would mean sitting in jail until then, but based on the violation, we'd ask the court to order.
Yes, Your Honor. Again, Mr. Rolfe is a business owner to require him to shut down his business on the busiest weekend of the year or 60 years. Seems like punishment before trial. And the countervailing argument is, well, what about protecting the children? That again, even if something were to suggest that there were people in danger in that theater, my client has never been accused of doing anything untoward with any customer. He's done everything he can to make sure that he has staff, at all times. In this particular case, he was left in the lurch. It would not happen again. He understands that, yes, the court would expect him to close down the theater. And, everyone in town would sacrifice so that the condition of the bond that he not, I don't know if grocery stores would have to close down or the roller rink. It just doesn't seem as though sitting in jail for the next 4 months because of this particular incident without a warning or another opportunity to learn from this would be the fair and just answer. Thank you.
You're welcome. Mr. Wallace, rebuttal argument?
Nothing further, Your Honor.
Thank you. The court files indicate, again, defendant is to have no contact with anyone under the age of 18. Clearly, that was done by the fact that there were children in the theater. Now, mind you, the court is not aware of any prior, this circuit court that is, not aware of any prior incidents alleging like behavior. So the court, I guess, presumes in some respect that other people have been operating the counter while this matter has been pending. And absolutely, Mr. Gus, I'm sorry, not Mr. Gus, but Mr. Rolfe is presumed innocent unless proven guilty in a court of law. And that's how we will move forward in this case. But relative to alleged bond violations, now not alleged, it's clearly a violation of bond. There's no question about that. And again, it wasn't part of the record, but an officer of the court had brought up Mr. Wallace, that is, regarding this particular issue with prior counsel. And apparently this was an issue or may have been an issue before. And there was some sort of conversation. Obviously, Mr. Champion was not part of that conversation, so he'd have no idea. And I wouldn't expect anything less than that. On the flip side, not to be in contact with anyone under the age of 18, it's argued by Mr. Champion, well, what about the grocery stores? You can't walk into a grocery store, there'll be someone there. under the age of 18, and presumably that's true. But I think that the idea here is protection of society relative to the allegations that, in part, the original case involves allegations where the venue is the theater. That's the allegation. Don't know if it's true or not, but that's the allegation. So that's the purpose of it. Again, the court finds a defendant in violation of the bond conditions. And the argument also that the court has to consider, well, he's a business person, absolutely is a business person. And the court takes judicial notice on the way into work this morning. They're saying that the Spider-Man movie apparently is one of the top, even may surpass Avengers, that box office sales. Get that, fully understand that. But the problem is, what if it were a weekend of a movie that's a dog, let's say, a movie that's not very popular? What would happen? It begs the question. Clearly, it's a violation. The court at this time is going to cancel bond in this matter. The court is not going to revoke it as into the monetary obligations, but the court is canceling bond. The defendant is remanded to the custody of the sheriff. That'll be all. Off the record.
Okay, friends, I'm going to be controversial here for a minute. For some of you, perhaps hard disagree with what just happened right there, and I'll tell you why. First, if the alleged crime took place in the theater, then whether he's the business owner or not, why did his bond conditions allow him to be in the theater in the first place? He could have had a manager or somebody else run it, another family member, whatever the case may be. So the bond itself sets him up for a failure straight away. There is no way that that man is going to be in a theater and not have contact with children, especially if he runs it, especially if he's responsible for the day-to-day operations of the thing. He's going to be involved. He's going to run across children. It's crap. It's absolute crap. Because there's no way that the court could have reasonably expected him to not run across children inside of a movie theater that he owns and operates. This was garbage. Absolute frigging garbage, the way they set him up. They never should have allowed him back in the theater in the first place. If the alleged crime took place there, for God's sakes, it makes no sense. Yes. Yeah, Barbara, it's an impossible situation. Exactly. They put him in a place where he was set up for failure by allowing him back in. They could have easily said, you can own it, but you can't be in it during the pendency of this case, and that would have solved it. They didn't do that. They put him in a position where at some point he was going to violate. It is garbage. It is crap. It is wrong. Hard disagree. See it differently? Let me know in the chat. So do we have our sidebar topic? Yeah, maybe, Lindsay. We can talk about it. I'm kind of passionate about this one. This was bullshit. Absolute bullshit. They set him up. Just my view. If you see it different, I'm willing to listen. Alrighty. Passion over. Let's go back to Judge West.
Good morning. You're Stephen Gray.
Yes, ma'am.
And this is cause number 26, DCCR 0294. Mr. Gray was previously in court, entered a plea of guilty to driving while intoxicated third or more. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor. Yes, Judge.
Any additions or corrections?
None of them were. Not from state.
All right, I guess y'all have all taken a look at what the recommendation is because of the positive alcohol screen.
Yes, sir.
So, Mr. Gray, it gives me a lot of concern that you showed up to probation and tested positive for alcohol when you are here on a driving while intoxicated third. So what that means is if I'm going to follow this agreement, then you're going to go in and get some serious treatment. And that's the only way I'm going to follow this agreement. Do you understand?
Yes.
All right. So this morning, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated third or more. I will sentence you in accordance with your agreement to a term of 10 years in prison, but probate that. Actually, I'm going to place you, the length of time, I know you guys talked about 5 years, but based on what I'm seeing here, I'm not going to follow that. I am going to order that you're on probation for 8 years. I'm going to order a $1,000 fine. You will be required to follow all of the rules and conditions of probation. One of those is you have to serve 10 days upfront time as a condition of probation. But more importantly, and in addition to that, I am going to order that you enter and successfully complete the substance abuse track of the ISF program. That's an inpatient program. You'll go in today, and then when you are out and released, you'll go through the JCDI program as your aftercare. And if you do everything you're supposed to and follow through with the treatment, then for all practical purposes, your case here in court will be over and you'll be able to serve the rest of your 10-year sentence while you're out on probation. But the other side of that is if you violate any condition of probation, you'll be back in court and you'll be facing that 10-year sentence that you agreed to. Do you understand?
Yes, I do.
I'm going to hand you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. Also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, sir, you can go back with the bailiff. Thank you, Mr. Parker.
Judge.
Yes.
Almost slips up.
See, Mr. Rojas, you have Tashawn Bass. Yes, it was. Hey, how are you?
Good, how are you?
I'm good. It's Monday.
And you're still good.
Still good. Hey, I've been called darling this morning, which is better than some other things that we call.
I never get called darling.
Darling.
Oh,
Oh,
thank you.
sweet Miss Lovely.
That's even better. Yes.
Good morning. Are you Tashawn Bass?
Yes, ma'am.
And Mr. Bass is here in 2 cases, cause numbers 25 DCCR 0832 and 0833, charged with aggravated sexual assault of a child. And what is the announcement?
Judge, Ms. French ordered the CPS records in June, and I don't believe they've come in yet. I checked this morning, they're not here yet.
Okay, yeah, I see that I signed that. We should be getting closer. So let's just do maybe 45-day reset so that we can see, hopefully we'll get those back. She can get them, y'all, everybody take a look at that and we'll see if we can get an announcement the next court date. Make sure you stay in touch with Mr. Rojas so that once he gets all that information, you can go over it with him and we'll get an announcement. All right, you're free to go.
She's a crimes against children
Yes.
judge. I will send her an email so that she sees it.
To follow up with you. Thank you.
Thank you, Judge.
Thank you. This is the day. Ms. DeLage, you've got Carly Davis.
Yes,
Looks like that's set for a plea. Are y'all working on paperwork?
we have, it's a partially agreed plea. We need to plea open as to the conditions of the probation.
Okay, you can just get all the paperwork done on that.
Okay.
Thanks. Mr. Jeffries, you have David Boyd.
Judge, that's one of Mr. Coleman's, and I've been facilitating, Mr. Jeffries had some questions this morning. If we could just hold it and get an answer on that, I think they'll probably both be announced and ready for trial, but I just want to make sure.
Okay, let me hold it just a minute then. Thanks.
I don't want to do that.
Yeah, that's right. He's in parking support this morning. But what is, do we have announced? Hold on a second. Let me look at what. Yeah, it's much better and it's a child version that. Okay. Mr. Gartz has Larry Fletcher with Mr. Coleman. Mr. Gartz has announced ready. What is this? All right, I'll number that one. And then also with Miss French, Mr. Gartz has Jesse Salinas, and there's an announcement of ready as well.
Could I hold on that, Judge? Pam sent a lengthy email to all of us over the weekend. I think she has received, I don't know, via a subpoena or an unexpected drop off of some voluminous discovery packet. I know she's talked to Mr. Gertz about that. Send it to him.
Okay.
So if his announcement has come subsequent to that,
maybe so.
I'm sure that hers would also be ready. I know she was up until that was dropped on her desk on
Okay,
Friday.
let me hold it and see if that has changed anything.
But I'll
Maybe
try
you
to
could do
catch
it.
her on a lunch break or something, but she did send us.
Okay, yeah.
She was expecting him to ask for the recess. She told her that.
Right. She just called.
Alrighty, friends, hour 3 of TCF Live. Seems like it's going to take a minute for them to find the next contestants. Let's go across the hall to Judge Stevens.
6-1. All right. There's hardly another more serious type of offense than what's alleged here. And that carries with it up to life imprisonment if found guilty. So. What are we doing today?
Me and Ms. Moore are going back and forth. She was at a seminar again. There was some notes left for Mr. Laird if we could ask it for a second.
This was indicted on October 30th of 24.
Yes.
It's going on 2 years on a aggravated sexual assault of a child. I get in trouble for that.
There was a
I know
certification, juvenile certification had to go through.
2 years.
It took a lot of.
Well, this is fast track and it's going to move real fast to try. Get ready, everybody, because this isn't the way the legislature intended these allegations to fester when it's a child. Let's see what's an 11-year-old and an 8-year-old as allegedly the victims. Okay. So what are we here today? What are
That mentioned something about, but
we just have a minute today?
We just have a minute. We'll talk. I gotta check something out here.
Okay.
I gotta look at some notes.
This is going to get on the trial docket and it'll be placed at an accelerated time period. That's the way the law requires it.
You're number one.
I'm number one without ever said.
So.
To Mr. Mayor and Judge Holmes.
Hey, Brian, I'm looking here. There's 5 separate cases, right? You've got 5 separate cases. Okay.
Yeah.
Okay. Get with him on how y'all are gonna do that, but those get one at a time and they wear everybody out, and they get stacked on top of each other.
That doesn't show
as punishment.
But I get
The way that's why those deemed them some of the most serious infractions under criminal law.
They're Balthazar, so.
Mr. Bassel? Yeah. Come on out.
I haven't sworn to it yet.
Okay. I'm gonna find you indigent here, but she's gonna swear you as to these allegations. This statement, this affidavit is all true and correct? So help you God, right? All right. In front of her.
Oh,
I just need to the right to right hand. Do swear or affirm the information and the true and correct. Okay, you can go back. Judge Hoover, explain.
No, he's got a conflict.
Oh, so just someone else will vote. Okay.
Yes.
Yeah, so they need something else. Yeah. Is it on?
James, you're first for trial.
May I approach you on? How could I be first when I've never set a case for fraud? We were in here last time.
It's on the trial docket.
Your Honor, we were in here last time and Mr. Elam was reset because he had 2 new burglaries. And you asked him if he was gonna hire me and he said, yes, I am. And of course, no, he didn't. I've been communicating with him the whole time, but we've.
How did he get on the trial docket with your name on it?
Well, I've never.
That's all I'm saying.
We've never stood.
I got 5,000 cases, so
we've never had a plea at all.
You were in court, that's why it's on the trial docket.
I did not put your honor, as an officer of the court, I've never placed this case on the trial. Communication with Mr. Elam has been.
If you judge it,
Extreme
you know these dockets out ahead of time, and I'm always available to help work things out.
Well, when we were in here last time, I'm not trying to interfere with the courts, and I apologize if it seems that way, but Mr. Elam stood right here last court setting. And
again, 5,000 people. I'm gonna have to trust what you're saying, you know, but it was, look, there it is. I didn't.
Oh, no, I understand. You know, I got the notice and I understand. I do understand.
That's, I'm just
when it was
looking at
emailed
this.
to me, I mean, Ellie emailed it to me, but again, you would reset the case because Mr. Elam was arrested on 126 on 2 new burglary cases. Or 1 burglary and I think another misdemeanor. And we stood right here and Mr. Elam said, you know, I want to hire Mr. Paget. He said, well, are you going to hire him? And of course, I didn't know because he doesn't communicate with me at all. And
So you don't represent him.
I do not represent him on the other case. I mean, I've got a state jail case I'm representing him on. But he has a burglary.
This theft of a firearm.
Right, I'm sorry. He has a theft of a firearm case. That's what I'm representing him on. But he also has a new burglary case that he was arrested on a warrant on 126 when we were in court.
Okay.
In court 3. So
well, I mean,
we came in here.
What we have.
We came in here a few months ago. We've never entered a plea on the case. You reset the case for him to hire me on the burglary or for us to.
Okay.
Try to work it out.
So
Never hired
then what are we gonna do and when?
Well, I'm here prepared. He's never communicated with me on this state.
What do you want to do?
I'm ready to go.
What direction do we need to do?
That's gonna be, I need to speak to Mr. Elam about that because.
Where is he?
He should be here.
Right.
Probably best if he comes up here.
He can't read your mind.
Just like we did last time.
Y'all gotta communicate.
Yeah, he did
and it's your
communicate with me and he
obligation.
told me that he could not hire me on the burglary case. And I said, well, I'm representing you on the state jail case, but
yeah,
we stood before you on.
We don't have to try both of them at
424.
the same time. I mean, we'll try one and then the other. But
That would be good.
when are y'all ready?
We had set
When
the
will you
case.
be ready?
I don't know how he wants to plead on this case because we have not talked about that because of the new burglary case. He understands the discovery on it. I've explained all that to him.
Okay, but it's over 300 days old. It's
Your Honor, I was hired on, we were in here on 122 of 2026. He was arrested on
6 months.
misdemeanor court. That's exactly right. He was arrested on 123 out of court 3 on his misdemeanor out of the same transaction. And then here we came back in April. And we stood here and you said, okay, get with Mr. Paget and hire him. And we got a date and we left, but we never,
never hired him.
I'm sorry?
I ain't never hired him.
Well, we know that. We're getting to another point, but we never entered a plea.
Your failure to move on your own and get something done on your own behalf is not going to stall us. We're going to move forward one way or the other. If you can't hire him, then if you're unable to hire him, we're going to get somebody appointed to represent you, but we're going to go to trial. And we're not going to wait for you in 10 years or 20 years whenever you decide you're ready for trial. That's not the way it works. Do you understand? Yes? Okay. If you can't hire him, let me know. Somebody will be appointed to represent you and you're going to interrupt. You get a chance to talk. We can't both speak at the same time. Both 2 people or more speaking at the same time.
On that burglary case, we did appoint Langston Adams
to that burglary case for him. So he does have representation
So,
on that other case,
yeah.
but this.
But how did
So he hired.
this one, how did James's case get onto the truck bucket?
Your Honor, I can assure you that
I'm asking her, let me ask her,
Okay,
see how she did.
I apologize.
Because
I did the same thing.
because I don't want you to come up when you don't need to. you know.
Judge, I don't remember, I just looked, we sent out a reset on April the 29th. And it was a setting for trial docket. No one has reached out and said it was an issue. So I can't tell you how it ended up in the trial docket. But no one's brought it to my attention.
Court gives me, if we're gonna, shouldn't I stand here and say, yeah, Your Honor, my client pleads not guilty
You
on the
would
case
think.
and we request.
You would think unless.
Well, there's a record and I assure you that never happened.
The only time it wouldn't is, y'all were supposed to be here, nobody showed up, so.
No, sir, we were definitely here.
Let me finish, James.
Yes, sir.
The only way that would have happened otherwise would have been y'all didn't show up. And then for an announcement, and then we just defaulted it onto the trial docket. But you would have been told that. We wouldn't have got you 4 months later. Somebody would have said, you didn't show up. This is what we did. What do you want to do about that? Do you want to move forward this way or not? I mean, that's the way we do things. I don't.
Judge, you want me to just pull my docket from April 20th?
Pull the docket and pull the record.
Yeah, we don't sabotage.
You know, I understand that's not the.
But you're not ready for trial, is what you're saying.
I mean,
okay.
All right. Well,
you know what? That's why God invented a number 2 slot.
Well, I mean, like I said, I understand the court's policy and I respect it, but it didn't happen in this situation.
Yeah, once again, 5,000, I got 5,000 and I just.
And I have all respect for the court and what's on
here in this thing. So
and I would
if you're not ready for it, that's okay. We can move it and figure out what he's going to do and how he's going to do it.
Before we have a trial setting, I would like to hear whether my client wants to plead. I've reviewed discovery with him. He has never told me what his wishes were. Because of this new case, you reset it for several months.
Well, did you want to put something on the record? What he wants to do? Or
Are you prepared now to tell me? Well, he has a burglary case too that I'm sure he would probably like to handle these cases together. He's never indicated to me that he wanted to not.
Or you helping him on the burglary?
No, I haven't discussed it because he was supposed to come to my office, so make an appointment and hire me on the burglary case, which he's communicated with me by text and said, I'm trying. And then a few days ago, I think he texted me and said,
we just don't wait though. It's like a train. It takes off.
And
if you're not on the train, you got to run after the train, which nobody can catch.
Is this pretty much what I told you, that we had to move forward and the judge is not?
I mean, other than.
Yeah, it says reset for trial on that, but that's all it says. Right, there's nothing else.
So
nonetheless,
so I do not.
What are we going to do then?
Well, what I would like to do, if Mr. Adams is appointed to him, I would like to.
Is he?
Oh, that's what.
Judge.
The burglary. He's represented and paid on the theft of.
Hold on, let me listen. When did Langston get up to?
No, cross your arms, get your hands down. It's okay. Speak up, stand up, and talk. Look off. Look right here, okay? Because
we're moving forward on the trial. That's what you want. You're going to move forward. We got to figure out which lawyer.
We need to see whether he's indicated.
Well, but you've got an obligation to also communicate with the people who are apparently representing you.
What I would like to do, Your Honor, is I would like to.
Everybody has that same obligation.
Sit down with my client, and then I would like to speak to Mr. Adams once he has an opportunity to review discovery and get a response from my client. I'm more than willing to go forward either way.
Okay.
Well, I've been hired on
whatever. It's been months since obviously something's been done. Let's move forward.
I think you gave him that much time to give him an opportunity to hire me, Your Honor. He's been unable to do so. And again, I don't want to hold up the court as quickly as Mr. Adams can.
Langston was appointed on the burglary case 1/23/26, so right after he was arrested.
Yeah, 8 months ago.
You said 122 or 123?
123.
Yeah, that makes sense. He was arrested on 123.
And you haven't even talked to him?
I don't know who that is. I ain't never get his contact information.
Listen,
There's a,
And Langston was here as well on that burglary case on April the 29th.
and we were in court on April 29th.
Yes, he was here with both of his attorneys.
Look,
So Mr. Adams
it's
is
reset
here.
1 week. It's reset 1 week, get a resetting and.
I'm ready. I'm fine. You give me a week. I'll be ready to
For
do whatever we need to do.
Cases.
Could you give me a little bit longer in
On
case I need to
announcement.
subpoena?
That's just an
subpoena?
announcement. So see where we are.
Give me enough time to subpoena.
Both cases, so both lawyers are here.
Status update.
Good,
I
that's what.
just want to make sure I have time to get my subpoenas out.
Okay.
If he wants to try.
So that puts Marvin back, Marvin Lewis with Trevante Nichols's.
You need to contact Mr. Adams. Do you have his phone number? Lacey, is there any way we could?
We're gonna alert him to be here.
Because I don't want to stand
So
up here
y'all
again
both can
not be ready.
figure out with him what's gonna
I'm
happen.
ready to move forward quickly as well, Your Honor. This is, I'm not.
Um,
A little bit.
Things that he's needed, right? You know what I'm saying? They give you, Mr. Adams contacts you, you need to get with him. We've only got 1 week. Do you understand?
Okay, and here's some, another case.
Okay. Hey, yeah. It's what, so we went from one side from there. I don't know if they feel that it's not. It's all happening.
Do you make one?
No. You need that. I'm not waiting for this. You know, going to work for it.
I've approved this,
I'm not waiting for it.
Could you take one day, I'll see if she has an offer in there and then, and it's, that's the communication issue.
That's what they. 30 years. This says, I don't know how to say
is Drummond Balthazar still? Is that you? Drummond Balthazar? Is Drummond Balthazar still here? No? Here, that's.
Alrighty, friends, we'll keep an eye on Judge Stevens' court here in hour 3 of TCF Live. Reminder, once again, 2:30 p.m. Eastern, 11:30 a.m. Pacific time, the debut episode of Second Session, our new live show here, right here on this channel. At the end of the stream, we will redirect you over there so you can set a reminder. But I hope to see you all over there. More Courtroom. You'll love it. Let's do this. Let's keep with this channel's promise of 9 to 11% more Judge Boyd and head over to San Antonio.
All right, and are you Mr. Perkins? We're here today for sentencing. And counsel, here you are.
Thank you, Judge.
According to your plea bargain agreement, punishment is to be assessed at a cap of 7 years in the prison. There's a $1,200 fine. State is opposed to your application. Have both parties had a chance to review the PSI report?
Yes, Judge.
Any objections to the PSI report?
Just to point out two things, both on page 1, it may be minor, but driver's license not on file, Texas. He's never had a license. It's not that it's not on file. He's never had a license. Guilt minimalized was, there's a box for an X on that.
Mm-hmm.
However, I thoroughly read the narrative. Mr. Perkins read the narrative, and I get that's more for arguments, but it clearly says for the instant offense, I had a firearm on me. I was driving. I got arrested for the firearm. I had a Glock on me.
Just 1 second, I'm sorry. Deputy, could you move them to the other end? And I'm sorry, you can continue.
I had the Glock on me. I misbehaved. I was on parole at the time. I shouldn't be carrying a firearm. He didn't, and again, this could be more argument, but I just want the court to know, in my opinion, it should be guilt acknowledged. He accepted that.
Yeah.
Aside from that, there's no corrections.
All right. Any witnesses state? Defense, any witnesses?
Yes, Judge. And may I call my first witness?
Sure.
I'm calling Tina Williams.
Mrs. Perkins, you're back against his counter.
And just
Hello.
make sure you speak loudly.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Tina.
All right, just make sure you keep your voice up so I can hear and the court reporter can hear.
Yes.
All right, defense, you may proceed.
What is your relationship to Charlie Perkins?
I'm his mother.
And it's safe to say that you know about his life. You raised him,
Yes,
right? And he has a son.
yes, he does.
Is this picture sticky? Sorry, picture of Charlie and his son.
Yes, it is.
And Charlie's son is named Charlie
Charlie.
Jr.
Yes,
Right. And how old is Charlie Jr.?
he's fine.
And prior to the arrest for this case, I had asked you to get some documents to show that he was employed prior to the rest of the case, correct?
Yes,
And these are some documents regarding the staff force, temp agency.
yes,
And these are various dates, end of 2025. There's multiple pay stubs showing that he was employed working through 2025, the end of 2025.
yes,
Separate from that, you tried, but you couldn't print out something showing that he was working up to the day of the arrest.
yes.
But
But I do have it on my phone.
on your phone.
Yes,
So
so it was daily pay that he would, they put it on in my account.
all right. And where's Charlie Jr. currently residing?
He was like,
And the other person in your household is your sister?
mine,
Sorry, I'm sorry,
my daughter,
your daughter,
Diamond.
Charlie's sister.
Yes.
All right. And you have nothing to do with this case.
Mhm.
The facts of the case, you don't know anything about this case, the car, the firearm. You weren't there,
I wasn't there. No.
right? Is there anything you want this judge to know about Charlie?
He's, since he's been out, he's taking care of his son. He's been trying to do the right thing to take care of him, be a good citizen, working.
All right. And you know that your son has prior criminal cases.
Yes,
The vast majority of them are juvenile cases.
yes,
As an adult, he only went to prison for one case.
yes.
How old was he when he went to prison?
I want to say it was about 18,
All right.
I believe, 18 or 19.
All right. I passed the witness.
State.
Just a few questions. So you stated that Mr. Perkins resides with you, correct?
Yes, ma'am.
And is your daughter an adult or is she a juvenile?
An adult,
She's an adult. Okay. And how long has Charlie been?
all of his life, besides the time he was in prison.
Okay. So in living with you, do you own a firearm in your home?
No, ma'am.
Did you know Mr. Perkins to own a firearm prior to this offense?
No, ma'am.
And you told defense counsel you were aware of his prior history, correct?
Yes, ma'am.
Were you aware that he was arrested for an unlawful carry of a weapon in July of 2021?
Yes, I did also.
You know how he got that firearm?
No, ma'am, I don't.
Do you know how he got the firearm in the instant case?
No, ma'am.
So you didn't have any knowledge that he possessed or owned a firearm?
No,
Okay,
I had never seen one in my house either.
okay. And so on these offense dates, do you know where Charlie Perkins Jr. was?
He was with me.
Okay. And you told the court also that Mr. Perkins was trying to do right. Is that a fair statement to say?
Yes, ma'am.
Okay, and this involves driving, correct? To do his job?
Yes, ma'am.
But you know Mr. Perkins did not have a license then, right?
Yes, ma'am.
And he's never had one?
No.
But
he's
you
never
know
had-
him to operate a motor vehicle still?
Yes,
And you know that's violation of the law, correct?
I did not.
No further questions.
Any other questions?
Ms. Perkins, does somebody have to have a license to drive a vehicle. In the sense of a vehicle is still safe from the manufacturer. It has tires, the engine runs, correct?
Yes.
A license, no further questions.
All right. I have a,
It's loud.
I think the phone is ringing. I have questions if there are no objections.
None from me.
All right. So here's the thing. The information that you've given me, it's surface level information, right? It's his criminal history. It's the driving without a license. I mean, we know we have to have a license before we get behind the wheel of the car. We know we're supposed to have insurance. Some people drive without a license. Some people drive without insurance. We all know this. But my question for you is this. Where did he go wrong in his life? Like why is he at 18 years old committing a robbery? Because I think that's what he went to prison for. Why is he doing that at 18 years old? Did he graduate from high school?
No.
Yeah. Did he get his GED?
He's working on it.
All right. So my question is like, why didn't he graduate from high school? Where was his family? Did nobody tell him, hey, you need to be in school? Did he drop out of school? Why did he drop out of school? What's going on? Because people will come into court and they always want to beg for mercy, right? Like, I know you don't want your son to go to prison. And what I can tell you is there is nothing that you can tell me that will be wrong unless it's not the truth, right? You know, your testimony to me is not going to be like, aha, she said this, so he's going to prison. I'm trying to wade through everything so I can make an appropriate decision on what is appropriate in this case. Should he go to prison? Should he not go to prison? So why did he turn out the way he is? Like, why is somebody not in high school? Why is he 18 years old and committing a robbery? This is the information I want to know, because then maybe I'll understand why is he on parole, which I'm assuming he was on parole from the robbery, and then he's driving around with a gun that obviously he knew he was not supposed to have, because the state just received testimony that he had an unlawfully carrying of a weapon before. And what I can tell you in the stipulated evidence, there was more going on than just the police pulling him over. It started with the legal tint on windows. Then it turns into he's not really pulling over. Then it turns into marijuana smell in the car and somebody spraying, air freshener or something to get rid of marijuana, which somebody who knows of this has just, informed me that you can't spray Lysol to cover up marijuana because you're just going to smell marijuana and Lysol. So all of that was happening on this day. So why is he 18 years old committing a robbery? And I say committing a robbery because he pled to it. And why is he not in high school? Why are we here? You know what I mean? Do you understand what I'm saying? So that's the information I need. This whole thing about he has a child he needs to take care of. I think you and I know the people who've been doing the heavy lifting of taking care of his child has been you. So that's what I want to know.
He's never liked school, and I'm trying my best to keep him in school. That's all I can
So you said he never liked school?
School was always hard for him.
All right. And hard, why? What do you mean?
His reading comprehension is not up to par.
All right. So why did that happen? Did he not go to preschool? What happened?
He's been to school all the grades.
Okay. And so how did you address the issue?
He was in the classes for ADHD and learning disability.
All right. So did you have him tested? Does he have a learning disability?
Yes,
and what was that?
Slow learning disability.
All right. And so knowing that he had those issues, how did you address that, or the school address that with him?
He was always in the 504 classes. And we did day by day work with him.
Okay. And then this gang affiliation that I'm reading about, where does that come in?
That I'm not.
Okay. Were you aware of that at all?
I was a little bit aware of it, but I'm not super sure about games and stuff.
Okay.
I was never that type to be around.
Okay. And again, nothing that you told me is to his detriment, because this is information I need to know so I can hopefully make the right decision, okay? So thank you so much for coming down. Is there any other questions?
Yes.
Yes.
On the PSI report, is this an accurate statement that according to Mr. Perkins, he was raised by his mother and his father? However, his father was in and out of his life. Do you think that his father in and out of his life had an effect on his education, his schooling, his upbringing?
It could have.
But you were always there for your son.
Yes, I was.
But he missed out on a fatherly figure.
Yes, he had no role model.
Right. And do you know where his father's at nowadays?
He lives here in San Antonio.
But not with y'all?
No.
Pass the witness.
You just stated that Mr. Perkins went through all grades of school, correct?
Well, I want to say to the 6th grade.
And then he dropped out?
Yes, not, well, he, until he was like in juvenile and going to jail.
Okay, and then he still resided with you, correct?
Yes.
And, okay, no further questions.
All right.
I was thinking of the kindergarten stuff.
Can I ask a question for clarification?
Yes, Judge.
So are you saying, and if I'm wrong, please correct me, are you saying that from the time he was 6th grade, he was in trouble and then juvenile stepped in?
Yes.
So 6th grade was the last grade he was in before he was in the juvenile system?
It's either 6th or 7th.
6th or 7th grade. All right. And what were his issues during that time period?
He was just misbehaving at school.
And did you go to juvenile court to help address those issues?
Yes.
Okay. And his son, who is staying with you, is he in school?
Yes, he is.
Okay. All right. Thank you so much. I appreciate you coming down.
Yes.
You're welcome.
If I may call my second witness?
Yes.
Diamond Perkins.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, sir.
All right. You can lower your hand. State your name for the record.
Diamond Perkins.
All right. Just make sure you keep your voice up so I can hear and the court reporter can hear. Okay. All right. Defense.
What is your relationship to Mr. Perkins?
Brother.
Okay.
All right. I know it's an obvious question, but just for the record. And you understand that you were here listening to all the testimony before with your mother?
Yes, I did.
All right. But you're not part of this case at all?
No, not at all.
You understand that Charlie's looking at up to 7 years prison?
Yes.
And just to distinctly clarify from your mother's testimony to what you're about to testify, Charlie Jr., you were in care of Charlie Jr. prior to your mother being in care, correct?
Yes. So, well,
you moved into your mother's house recently?
Today I am living here.
Okay, so prior to today, Charlie Jr. has been with you somewhere else?
Yes. My own apartment.
Okay. And if Mr. Perkins gets released, does he plan on moving in with you and your mom?
Yes, but we're trying to, if he gets released, I'm trying to move somewhere else so that way he can, because he helps me with my 2 kids as well. So I was trying to move so that way he can be stable, because he gets around his group of friends and he doesn't know. He has too many peers around him to where he cannot function and like focus on what he really needs to get done. So
he needs to be in a better neighborhood.
Yes. Better city, something.
And
he needs to get away from it. I will start there.
Is there anything you want this judge to know about your brother?
Yeah, if I can say okay, so me and my brother, we're the only 2 siblings that have the same mother, same father. So as far as him growing up in life, he's seen and done a lot. or whatever, but my mom, she's always working. I helped her take care of my siblings and everything. She's always been working, and then I work in 2 jobs helping them when she can, when we're around her or whatever. But I would say he started like that after he realized the type of father we had. Like my dad's an alcoholic, so as far as him trying to figure life out and the incidents that happened as far as my mom and my dad with him being present there is when he spiraled out of control. And then as far as controlling him, I drift off and went to go have a kid with my child's father and everything. So I stopped being around him, and that's when he went to jail for that robbery and everything. Like it's just mostly guiding him and hey, no, chill, no, or whatever. So as far as that, no, he has not had that in a minute since. Honestly, since I've been back and forth having my kids. So I leave and because we were both staying at my mother's house, and when I leave or whatever, and I'm like, okay, I'm going to go move over here for my child's father, then that's when I'll start getting little phone calls and stuff, hearing like what happened and stuff. And then I'll be like, hey, what are you doing? Like, you have to literally redirect him daily. Like, sir, no. Like, if he has that around him, he's going to pick up with it because that's what he feels it's it, but it's not. When he's with me and he helps with the kids, he is amazing. I will give him that. If he's living with me, inside with me, daily, I have him doing stuff because I don't have time for all of them to be over here. I have kids. I don't know. You can clean, you can help, you can work, you can do all of that. But all that extra friends, no. They're not allowed because they're not the best people to partake in and everything. But I will say, when he's away from them, he does better. Like if you have to like honestly force him to do it, he's going to. Like it's not too much of a he's the worst person in the world. He's not, don't get me wrong. He has prior convictions and everything, but he still needs a lot of growing as well. I will say this last time that he did just get out, he has done better. He was like, oh, I'm not going with them this time. Oh, I'm not going with them and stuff. Like he will sit up there and start taking control of his life. He did start taking control over it and stop letting them call him and be like, hey, what you doing and everything. I will say that.
No further questions.
All right. State.
Yes, very brief. Who is older, you or Mr. Perkins? You, how much older are you?
I'm 27 and he's 24, 25.
Okay. And you stated that you are moving in with your mom, but if Mr. Perkins gets probation, y'all will both move out together. Is that?
Yes.
Okay.
I'm trying to at least better him so that way he can do what he needs to do because I have his child and it's not even just his child. He takes care of his stepdaughter. He takes care of his son and my kids.
Okay.
They all have.
Okay, I'm gonna break it down a little. So Charlie Jr. is 5, correct?
Yes.
And how old are the stepchildren?
So today's August. So she'll be 7, August 24th.
And then your child, how old?
Mine's 8 and 3 and 4.
And are those nieces and nephews? Or
Yes.
You said 8 and 3?
Yeah, 8 and 4.
I'm sorry, 4. Okay. And do you work full time?
Me? Yes, from here and there, no.
So not full time, but you do have
Yeah,
employees.
yes.
Okay. And when you are at work, who watches the kids?
I work during school hours. If I have to work outside of school hours, they will either go with my mother or if he's home, then that's who he doesn't be with my kids. He does.
And you realize that probation requires a lot of personal responsibility on the
Sure, yes.
Okay. And that he's gonna have to step up and do the things he needs to do, right?
Yes.
Constant guidance.
Yes.
And you also realize as his sister, although you want to guide him and do right by him, he's gonna have to make the choice, right?
Yes.
Okay, so how can you assure this court that Mr. Perkins is gonna do what he needs to do to be successful, because he hasn't in the past.
I know, and that's the problem. We have not fully moved in together. Like, he's always been at my mom's and I've always been going and having my kids. But as far as assuring him, is the fact that I know, because he knows his kids and he knows my kids. He knows what I allow, what I don't allow. So as far as all of that, he knows I'm very secure with my kids. I don't allow any of that around my kids, because at the end of the day, my kids are in my care. My kids are in jeopardy of your stuff. So,
Okay. And then do you view your brother as a good role model for Charlie Jr.?
as far as, yes, and while he's in his presence, yes, he makes sure he don't cuss around him. He makes sure nothing, like, he goes and takes him places and does everything. He put the kids in football. He'll take them, go get ice cream, take them, yes. But as far as his prior conviction, he honestly, his dad probably, I mean, his child wouldn't even probably know that he had those if he was honestly. I'm pretty sure he wouldn't even know.
So it's your testimony that you believe Mr. Perkins is a good role model for Charlie Jr.?
I do.
Okay, and how do you reconcile him being a good role model for Charlie Jr., but still engaging in criminal activity?
I wouldn't say he still engages in criminal activity. I do understand that he did have a gun prior to him getting pulled over. How did he get that? That part I don't know. But at the same time, I have been back and forth and have not been around him daily. So that part I do not know.
Okay. And would it surprise you to learn that Mr. Perkins was also arrested and had marijuana in his possession?
I did not know that at all.
Okay, and do you know Mr. Perkins to have a driver's license?
Oh, no, he does not have a driver's license. And I will say that fell to being in and out of the system. Like, he'll get out and then other things will happen and then he'll go back in. So as far as him actually being stable, I'm for sure he will go get that. For sure.
Do you know Mr. Perkins to operate motor vehicles with either his son or your children in the car?
Oh, no, I don't let him drive with my kids. I'm for sure. I do not let him drive with my kids, his kids. No.
But you're not around 24/7, correct?
I am around my kids, but as far as when my kids get left with my mother, because he's not allowed to drive my kids, they stay with her. But he does not drive around his kids, my kids. If they want to go somewhere, we can all go. And that's how I do it with him. You can ask him for himself. He does not drive my kids or his kids.
Thank you.
You're welcome.
All right, any other questions?
No follow-up.
All right, thank you so much for giving me some insight.
Yes.
All right, thank you.
Last witness,
Yes.
Charlie Perkins.
All right, do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Charlie Perkins.
All right, and before we begin with questioning, here's the thing. I know that people say they have bad childhoods, their father's not in their life, maybe their mom's not in their life. But you know what I always want to know? At what age do we reach when all of our decisions are our decisions, and it's not because my father wasn't around?
I'll blame your own.
No, I'm just putting that out there. So now when questions are asked, we'll see where we go, okay? All right, you may proceed.
Mr. Perkins, you're telling this court and the PSI officer that you were driving and you had a firearm in the vehicle, correct?
Yes, sir. Yes, sir.
Where it says guilt minimalized, guilt declined to discuss, and guilt acknowledged, there's a mark on guilt minimalized. You see that?
So,
But you're saying that and I underlined it. You're driving, you had a firearm, you had a Glock on you. You did this, you misbehaved, you're on parole, you shouldn't be carrying a firearm. Correct. I believe your mother said that the last grade you attended was your 6th grade, but I believe it was your 9th grade? 9th grade. And you didn't know this until the PSI came up, but you have a 2nd grade reading level, correct?
and I did have to read grades.
spelling?
I can read good, I read myself just all day.
Is it comprehension?
That, like, I can read. I just ain't spell them.
Okay.
And you were in special education classes while you were in school? Make sure you speak loud. When you were on parole, that was around the end of 2024. So from January 2022 through pretty much the entire 2024, you were in prison.
Yes, sir.
Maybe early January 2025, you're on parole. And from that time till you're arrested, you had work, you're employed.
Yes.
During the time you're on parole, you were a victim of a ag assault deadly weapon. You were shot.
Yes.
Do you know if the person was ever arrested for that offense?
I don't know.
You were taken to a hospital for the shooting.
Yes, sir.
All right. Law enforcement never followed up with you?
And I'm sorry, when would this have been, counsel?
8 months prior to February 2020. About 8 months prior to February 2026. And you know that as a convicted felon, you cannot possess firearms.
Yes, sir.
On parole, you cannot possess firearms.
Yes, sir.
On probation, you cannot possess firearms.
Yes, sir.
Even if you had waited out the parole or discharge, there's a 5-year period where you still cannot possess firearms. You understand that?
Yes,
sir. The area you're at where you're shot, the area where you associate with, you don't want your son growing up and being around the same area as you, correct?
Yes.
You want your son to have a better life than you. The prior gun case the state had referenced an unlawful carry weapon. That was a misdemeanor unlawful carry weapon in 2021, correct?
Yes, sir.
So you were not a convicted felon until January 2022?
Yes.
You understand the judge can sentence you up to anywhere from 2 years to 7 years prison?
Yes.
You're asking the judge to give you probation?
Yes. Yes.
Is there anything you want to tell the judge in asking her for considering probation?
Yes, I know I was on parole. I wasn't scared to carry a gun. It wasn't an accident. I did it. I was just misbehaving. I got shot, so I just kept protection. I know I ain't supposed to keep it, but I have my protection. I just kept a gun on me. But I was trying to get probation or whatever, so I could just try to get probation and move out of San Antonio and change my life. I was taking my son when I came home, put him in school, I put him in football. I was doing what I had to do, but I didn't know how to carry a gun. You know, the gang members and all that. I didn't want to die, nothing like that. So if I move out of San Antonio, get a job, just work and do what I do. I ain't gotta worry about nobody shooting my car, doing none of that. So I put 10 on my cars. I was just shot in my bed.
And I believe in the PSI, there is some mention that you haven't been associated with the gang since 2020. All right. Pass the witness.
All right, state.
Yes, Judge, just briefly. Mr. Perkins, on the offense date, why did it take you so long? Or I guess not so long. Why were you leaving and didn't immediately pull over?
I put up to the road place, cause I was already down the street from where I was going to, so I put up right there. I was gonna pull up right there.
Okay, and then when the officer approached, the report states that he smelled air freshener. Do you remember reading that, Mr. Beach?
Yes.
Did you spray air freshener?
I just I always kept my car clean. Cause I know I carried a gun, so I'm like, I'm gonna keep it clean. I ain't spraying the air freshener, I ain't doing like that. I ain't spraying, they said I spray something, but I ain't spraying that.
Okay, and were you able to detect the scent of marijuana yourself in the vehicle?
No.
Okay, and were you surprised, I guess, when the officer did find marijuana in the car?
Yeah, but it was like less than the ground. I be having people in my car, so it less than the ground. It was like less than the ground.
So is it your testimony that wasn't the marijuana in your possession was not yours?
It was like less than the ground, like on the floor and stuff. You just scraped it up. You know, it was like that. It wasn't like bags of weed or nothing like that in my car.
Okay, and whose car was that?
It was in my name.
Okay, and how did you get that vehicle?
I was working, had a job. I was saving my money. I had bought me a car. They sold me a car with no license. I bought me a car. I needed to get to work and stuff.
Okay, so even though you know you don't possess a license, you thought the best decision was to get a car so you could get to work. Is that fair?
Yeah, I got insurance, but I was trying to get my license, but I just never went around to it. I was too busy working and stuff.
Okay, and how did you get the firearm on the instant offense day?
I had got it. I was riding. I always kept going up to my protection.
Yeah, but my
After I got
question is,
shot,
how did you get it?
I had got it, like bought it, like spent some of my money. I check money and stuff like that.
Who did you buy it from?
I don't really know like that.
Okay, so you remember in the stipulations, right, when the officer ran the gun, it was returned to be stolen? So
I didn't steal it or nothing like that.
you purchased a gun from someone and you didn't know the whereabouts, is that fair to say?
Yes, no.
Okay, and on direct, you testified that you know you're not supposed to possess a firearm, correct?
Yes, ma'am.
So how can you reassure the court that this time is gonna be any different than the past?
Cause if I was to get probation, something like that, I'll move out of San Antonio, just do right. I ain't got no people trying to kill me or nothing like that. I ain't got to look behind my back. I know I ain't gonna carry no gun because I ain't in my San Antonio, I ain't in my city. So I just do what I need to do, take care of my son, do what I gotta do.
Where was Charlie Jr. on this offense date?
I believe he was at home. I just
Okay.
got out of work early that day.
And then on the June 5th, 2025 robbery date where you were a getaway driver, where was Charlie Jr.?
He wasn't even born yet.
2022?
Yeah, I don't think he was born yet.
That was 4 years ago.
He probably was. I don't really remember, but he probably was born. He was probably at my baby mom's house or his mother's house, something like that.
No further.
Any other questions?
Yes, the robbery date was 2020, June 2020. So technically, your son wasn't born yet in June 2020. But
Yeah.
when you were,
That was my year address conviction date.
but when you were sentenced, it was January 18, 2022, where your son had been born. No further questions.
All right. Any other witnesses?
No other witnesses.
State any witnesses?
No, Judge.
All right. The court will hear argument. State.
Judge, we ask that you deny applications for deferred in probation and sentence to 7 years in the prison. Mr. Perkins, although I will concede that he admits to possessing the firearm and then operating the vehicle that he purchased, he continues to engage in criminal activities. I don't think he would be a good candidate for probation because he's his mom and his sister, and he even states that he intends to reside with people that he has been with when he gets into his prior, or when he got into his prior incidences of crime. So I don't think that's a good environment for him, and I don't think that he will be successful. He does have a prior MTR, and he was ultimately revoked because he pled true to the #1 UCW. And although that UCW date occurred prior to him being convicted on the robbery, he's still possessing guns. That's the issue. So boiling it down, Judge, I know he's aware that he's not supposed to possess these guns, but he continues to violate rules, and I just don't think he's going to be a good candidate.
All right. Defense.
Judge, the priors that he's had as an adult is one conviction. He has a lot of juvenile cases that I would hope that you wouldn't use a juvenile against him. The juvenile cases appears to all be misdemeanors. I know that robbery is a serious felony. He has about 4 months left on parole. He has a parole hold. He can't get out. He never got a GED. He has a 2nd grade reading, writing skills level. There was mention of a ISF, cognitive behavior, MRT. He's willing to go inpatient, and I would like it if you could order him to get a GED also, improve his job skills. He knows that he can't have a gun. He can't have a gun for protection. He doesn't want his son to be in the same area and neighborhood that he grew up. He wants to take his son and go outside San Antonio. The only investigation, to my knowledge, that happened with him being shot was the law enforcement seized his phone to see if there's any information that they can get from a phone, but they never gave him back the phone. There's been no follow-up where he was shot. He went to a hospital. They gave him some pills. They never gave him surgery. He still has a bullet in his back. He didn't have to go through rehabilitation
Wait a minute. So he went to the hospital
for 2 days,
for 2 days.
and they gave him pills and he
They
walked
didn't
out.
perform surgery, didn't remove the bullet.
And they didn't investigate who shot him, but they kept his phone.
Oh.
We can't make excuses about his father not being in his life, his
Let me
education.
ask you this. So do you know personally that he went to the hospital and they just gave him tablets, or is this just through your client?
Through my client, and interviewing him before the PSI.
Okay.
But there's no case where he's listed as a victim. The only case he has is this case here that the state has. We're asking for probation, 7 years probation. I think a structured environment would
So
help
is
him.
there any proof that he filed a report and was shot?
I wouldn't do that, Judge, unless I charge as a key. This is the first time I've heard this.
I was on the news when I got shot.
Oh, well, let's Google.
Let me Google it.
And was that before this offense?
That was when I was on bro. Just
No. My question is, this shooting, was that before this offense? Right, if you all want to step back and see if you all can find that, and then,
Yes, Judge.
and who knows? Maybe the state may decide something else. I don't know.
Have a seat.
All right, who's next?
Okay, friends, hang tight here a second. We'll go into overtime if we need to, but we're a few minutes in the Wayback Machine, so I'm going to check and see if they come back before we catch up to live. Yes. Yes. Okay. Resuming.
And if I may show you my client's sister's phone. This is a photograph taken September 12th, 2025, and you can swipe it to the right. There should be,
Oh, no, I can see. All right.
in the September 12th, and I'll swipe it. There's a few pictures. And that date, September 12th, lines up with the KSAT news article from September 12th, 2025, where a man is dead after double shooting near East Side Sports Bar. It was a Vibe Sports Bar. Charlie Perkins was shot in the leg, but went through the leg, the butt, and the bullet ended up in his back.
And what day of the week was that? Do we know?
I can, September 12th, 2025.
Friday? And does anybody know what time that was?
The investigator said he is sending a reporter.
Oh, okay, we'll have the report. Are you okay to
Set back?
remain? Yes.
Yes.
All right, thank you.
Thank you.
All right, anyone else ready?
And let's check again, because we're still a few minutes in the Wayback Machine. See if they come back again. Not him. Not him. Not him. Not him. Okay. So here's what we'll do, friends. I will keep an eye on this court, and when they come back, we will pick that up tomorrow. I will save the spot. Oh, that's a... Hold on a minute. We're gonna overtime this overtime, because what in the world just approached here? This looks like a 5-year-old, I swear to God.
All right, what's happening on Yandell?
Judge,
Miss Yandell, if you'll come forward, please. So what's the,
we got, this is what I was just talking with the state about, and I guess we're a little uncertain about some of the procedures.
okay.
So there
So
was
was she declared insane?
at the time of the offense, they said, the doctor did say that she believes that she was. So With the disagreement we're having is because I said if she goes not guilty by reason of insanity,
Yes.
whether it's plea or trial.
No, it's what ends up happening is that if somebody's found deemed to be insane at the time of the offense, you can either enter a plea if both parties agree to the doctor's findings, and then she will enter a plea. You'll be placed on a form of probation. And whatever the range of punishment is for your offense, that's how long you'll be under supervision. So if, for example, let's just say it were a robbery case, and I know your case is not a robbery. If you were deemed to be insane at the time of the offense, well, the range of punishment for robbery is 2 to 20 years. So you'll be supervised for up to 20 years. But it won't be through this court. It'll be through the magistrate's court. And the magistrate's court will hear her plea.
And Judge, so this is where our disagreement is, because the state is stating to me that they believe that she is automatically committed to the state hospital. And I said, I don't believe that's accurate. I believe that the court and the judge makes a determination on how it was to.
Well, what I can tell you is according to the law, if it's a violent offense, you are supposed to be committed to an institution. However, if you're already under medical care and the judge, through testimony from experts, determine that you're not a danger, then they may decide not to place you in an institution. So it's completely up to what the doctor says. But legally, according to the code, if it's a violent offense, you're supposed to go into an inpatient facility. But in your case, if there's a doctor who says something otherwise, then you may not end up going to an inpatient facility. It just depends on whatever the testimony is going to be and whether they make a determination on her med compliance.
Sure. And it's because, and I obviously I haven't done a lot of these, but I just, my position is that I don't think it's just automatic that she has to go into the state hospital. So,
well,
but I hear what you're saying.
Yes,
You're saying
yes.
with the crime of violence.
Yes.
So.
But I've seen people that have been found not guilty by reason of insanity, and safeguards are in place and they're not placed in the institution to begin with. But it just really depends on the testimony. But what I can tell you is, according to the code, inpatient is the default.
And so I think at this time, Your Honor, what we want to do is we want to go ahead and get a trial setting for this. And then I will communicate with Judge Rodriguez over there about this more. And then we'll come up with the trial setting and then.
Now, let's do it this way. Let's refer it to magistrate's court to see if there's going to be any objections to the insanity plea. Then you can discover from the doctor down there whether or not they would seek to place her in an institution, because if they're not seeking to place her in an institution, then this may be all for naught.
Okay.
So Norma, if you can transfer this to the magistrate's court for a hearing on the NGRI.
Yes, ma'am.
And can you find out when they're able to do that so we can just give her the setting date?
Yes, ma'am.
All right, just have a seat and we'll get a date for you, okay?
Thank you.
All right, thank you.
Thank you, Judge.
Okay. I was ready to be done and I saw that person approach and I couldn't believe what I was seeing. No shade, but that looks like a child. And the idea of a violent act coming out of that person is very interesting. So let's try and keep an eye out for her and see. It's going to the magistrate court. They don't stream, but perhaps we can catch something after the fact. Before we go, Lindsay, thank you for the $10 for overtime. As well, you were asking about correlation between learning disability, neurodivergency, and gang affiliation. So I had my buddy Super Grok write up a report on that. And the summary of it is this. Yes, there's research showing association between learning disability, neurodevelopment conditions, and higher rates of delinquency, including gang involvement, though the links are correlational, often mediated by school failure, social factors, and other risks, and not deterministic. I have the entire report that it gave me, and I will share the link in the mod chat backstage so we can take a look at that together. Anywho, that brings it to a close for right now. I will keep an eye on Judge Boyd's court, and when that case comes back that we were watching earlier, I'll try to capture that and we can show it tomorrow. But second session in a little over 2 hours, and we will redirect over to that at the end of the stream, so you can set your reminder, 2:30 Eastern, 11:30 a.m. Pacific. So do join us for that. We'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. The wisdom I leave you with this morning: if your enemy is hungry, give him bread to eat. And if he is thirsty, give him water to drink. That is from Proverbs. Do consider that. I hope to see you all in a little over 2 hours right here on this channel. In the meantime, go enjoy your day. Take care. God bless.